call the Physician Assistant Board to order. Today is October 24th. We are meeting at Marshall Ketchum University Tech Health Facility. I would like to take the opportunity before I call the roll to thank Marshall Ketchum for allowing us to conduct our meeting here today. It's a wonderful facility. Dr. Kevin Alexander, who's the president of the university, is the one responsible for starting the PA program, and as a result, we have a great place to meet in Southern California today. I'd also like to thank Dr. Julie Shonak, who facilitated this along with Matt, who just left, and also Bryce, who is doing our webcast today. So the first order of business will be roll call. Julie?
Good morning. Charles Alexander.
Here.
Jennifer Carlquist. Present. Sonia Early. Michael Bishop. Javier Escobar Acosta.
Here.
Jed Grant.
Here.
Catherine Hazelton.
Here.
Javier Martinez.
Here.
Robert Sachs.
Here.
Mary Valencia.
Okay, we have a quorum. The next item of business, taking it out of order, I would like to announce that we successfully recruited and appointed a new executive officer, Lynn Forsythe. She has been with the board for 10 years, and it was a unanimous decision to select her, so I'd like to congratulate her. As of September 1st, she took over as executive officer, and we threw her a pretty good curveball right off the bat by having a meeting in Los Angeles instead of Sacramento. So, welcome aboard under a different capacity.
Yes, thank you very much.
So next item of business will be approval of the April 18th minutes. Does anybody want to make a motion to approve?
Any amendments?
Can't do amendments without a motion.
I know, but if the motion could be to make an amendment to the minutes before.
I make a motion to approve.
Do I have a second? Waiting for a second.
I was here.
Hmm?
Yeah,
Dr. Alexander.
Dr. Alexander, second.
Okay, all right, further discussion. You can come in, Sonia. All right, public comment. There being none, all those in favor of accepting,
Make the roll call.
do roll call
Yes.
again? Of everybody or just?
All the people that are present. So,
All right, Julie, call the roll again.
Okay. Charles Alexander.
Aye.
Jennifer Carlquist. Here.
do you
Javier.
please support the motion?
Aye. Javier Escobar Acosta.
Aye.
Jed Grant.
I'll abstain because I wasn't here for the meeting.
Catherine Hazelton.
Aye.
Javier Martinez.
Aye.
Oh, sorry, Xavier Martinez. Excuse me. Robert Sachs.
Aye.
Mary Valencia. Sonia Early. Aye.
Okay, so the April 18th minutes are passed. Okay, so now we will move to approval of the July 11th minutes. Do I have a motion?
I'll make a motion
I
to
have a
approve.
second.
Second.
Discussion. Public comment? Can we call the roll, please?
Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert E. Sachs,
Aye.
Mary Valencia,
Okay. The July 11th minutes passed. Now we have approval of the August 25th, 2016 teleconference meeting. Do I have a motion?
I'll make a motion to approve.
Do I
Second.
have- Okay, discussion? Public comment? All right, can we call the roll, please?
Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Okay, that is carried. Next item is, I need to read, public comments on items not on the agenda. The board may not discuss or take action on any matter raised during the public comment section that is not included on this agenda, except to decide whether to place the matter on the agenda for a future meeting. Next item is number 7, nomination and election of physician assistant board officers.
So, just for the record, there was no one that wanted to make a public comment, right, for items not on the agenda? Okay, thank you.
Okay. And I will turn that over to the executive officer.
Business and Professions Code, section 3509.5 states that the board shall elect annually a president and vice president from among its members. Typically, the nomination and election of board officers is held at the last meeting of the year. Do I have a nomination for president for 2017?
I would like to nominate, Mr. Sachs for president.
Second.
Could I have a show of hands of those in favor of Bob for president, please?
Before you do that, can you ask if there are any other nominations?
Oh, I'm sorry, is there any other nominations? Seeing none, may I have a show of hands in favor of Mr. Sachs being president? Okay, it's unanimous.
Okay, so just for the record, the board has traditionally, for open session items, we do a roll call to count the votes for the record.
Okay.
So that's the procedure that we use for open session matters. Closed session, you can do any way you'd like. But, just for consistency, since you have adopted the procedure, that you're going to do a roll call so the staff can easily identify who's in favor or who's opposed or who abstains or recuses for any particular motion, then I would recommend you keep doing that.
Do you want me to do call? Okay.
I would just recommend that.
Okay.
If Julie feels comfortable that she knows who voted for this particular motion, then I'm okay with it, but just going forward, I would recommend that you stay
I can call
consistent. Okay.
Dr. Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
and Mary Valencia. Okay, congratulations.
Thank you.
Okay, now, do I have a nomination for vice president for 2017? Mr. Sachs.
I would like to nominate Jed Grant.
Second.
Second.
Do I have any other nominations? Okay, seeing none, I'd like to call roll. Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
and Mary Valencia. Okay, congratulations. We have a new president and vice president for 2017.
We get a hand too?
No.
Okay, thank you. Next item will be President's Report. I attended, along with many of the members, the Kappa Conference in Palm Springs. It was their 40th anniversary conference, well attended by PAs. They did lots of special things because it was the 40th anniversary. It was a spectacular meeting. Both Jed and Jennifer gave lectures at it, which were very well received. We had lots of individuals stopping at our booth. Besides all the other challenges I gave Lynn, they printed or had printed 250 laws and regulation books that we passed out. They went like hotcakes. The interesting thing was, on more than one occasion, they would grab it and look through it and they'd go, how much does it cost? And it was like, well, actually it's free. It was like, can I have two? So it was a very productive meeting, and I think it went over well. It was also the last year in Palm Springs. Next year, the meeting will be in San Diego at the Sheraton, and they changed the date so that it will be in August instead of October. So we're looking forward to next year's. The other issue is the National Commission of Certification surveys state regulatory boards. This kind of became an issue. I read it in an article from the NCCPA newsletter that said they had conducted a survey with all 50 states' regulatory boards. And so I called the office and said, I don't remember seeing anything like that. Did you see anything like that? Did Glenn see anything like that? And I got a profound no. So then Lynn contacted the NCCPA and got somebody, and they had no clue that had been published in their own newsletter, and subsequently denied the fact that the survey had gone out. There are a lot of issues between NCCPA and the AAPA going on right now about certification, but we're going to have to talk about that in January. So that concludes my presidential report. Public comment?
Any questions from the board members?
Okay. Board member questions? Public comment? All right. We go to the executive officer's report.
The Breeze team, in cooperation with the boards, has developed a no longer interested interface. This interface is designed to automatically send no longer interested forms to the Department of Justice based on the status of the license. Previously, it has been board staff's responsibility to send the no longer interested forms to the Department of Justice for processing. This new feature will help reduce the amount of records in the holding tank. It's the database for licensees that the board receives information from the Department of Justice, thus generating reports only on those licensees that are current. CME audits have been implemented finally. Breeze randomly selects 1/12 of 5% of the licensing population each month, which generates approximately 45 audit letters per month. The selection is based only on current licensees. So that our first batch went out about 2 weeks ago, and we sent approximately 80, and one of our board members was selected randomly. So he's dealing with that. I recently went to a week-long training for the new QBERT reports that are being introduced in the Breeze section. Those reports will take the place of current ones, and they're going to be phenomenal for the board members to see. It's going to give you everything you want to see and probably more. Last week, Julie and I conducted interviews for our part-time licensing position that is open. We had 2 candidates that we really liked, however, they both declined our offers. So we are going to be interviewing again next week for that position. Once that position is filled, we will be interviewing for the enforcement position, and at that point, we'll be fully staffed. Right now, there's only 3 of us in the office, so we're manning 5 different desks between the 3 of us. I'd like to take this opportunity to thank the medical board staff for all of their help and support, as well as DCA's executive office and all their department heads. Julie Shornack for having us here, and Matt. And I'd also like to thank staff for all their hard work and getting us through these past few weeks. So thank you. Any questions on my report?
I have a
Yeah.
question. Oh, go ahead.
Just a question, given the short staff, has it affected approval dates for PAs seeking license renewals?
No. Julie and Anita have been running the desk jointly, and if an application comes in and there's no issues with it, it's still being processed within 30 days.
Great.
So it hasn't held us up. They're averaging 35 to 40 new licensees per week right now. So if anything, their workload's increased.
Good work.
So, I'm sorry, go ahead.
Why did they decline the offers? I'm just curious.
One lady was working full-time commuting to Vacaville, and it was financial reasons.
Okay.
The other gentleman was offered a full-time position instead of the part-time position,
Okay.
that's why.
Thank you.
So could you go over if it's part of this or if it's covered later, because I think this is the first time we've audited for CME, kind of what the process is, they get a letter, how long do they have to respond, that kind of thing.
I would recommend this be on a future agenda item because it was only noticed for the Breeze implementation piece of it.
Okay.
So if you wanna go into more detail about CME audits, I would recommend it be a future agenda item.
That's fine.
We put it on the next agenda.
Okay, just so that everybody has a clarity about what's
Yeah,
happening.
we'll put it on the next agenda.
Do we have anything on the website about it?
We are working on that,
Okay.
yes.
So it's not fair to send out a notice and not let them know what it entails and so forth.
It's being worked on, and hopefully it'll be up on our website in the next week or so.
Okay. Public comment? Okay. Next item, licensing, please. Julie.
Hi.
Morning.
So the Physician Assistant Board's annual statistical program data for the licensing period of July 1st, 2016 to October 10th, 2016. Initial applications received, license type 335. Initial licenses issued 350. Licenses renewed. All status, it would be 1,406. Current status, 1,395, and current inactive is 9.
And do you have what our total licensees are?
I think it's just over 11,000.
Wow.
11,044.
That's awesome. Comment on the licensing report? Public comment? Thank you, Julie.
Great work, short-staffed, lots of licenses, that's awesome.
To redirect towards Catherine's question with renewals, renewals aren't so much affected with the internal process of the office because a lot of people are taking advantage of the online. So we do have a lot of assistants helping people through that process. It's catching on, but we're still doing the paper ones. So for the workload into the office with renewals has really decreased because of the online renewals. So whereas Nita's desk, I don't know, she may have processed between 30 and 50 renewals a week. I'm processing maybe 20. So it's considerably less now since online. So it's alleviated that a lot. So
Good timing.
yeah.
I can tell you, I had a student come up to our booth at CAFA, and she had just been notified that she had passed her exam a couple of days before, wanted to know how long it would take before she got her license. So I called Lynn and Julie, and they said, tell her to look on the website at 1 o'clock today, it will be there.
Wow.
Big smile. Very happy student. So they're doing a great job, all of the staff up there are. Okay, next item will be diversion program.
Okay, as of October 1st, 2016, voluntary referrals are 5. Board referrals are currently 9 for a total of 14. And to date, we have had 139 participants in the diversion program. Any questions? Thank you.
Just for the new members, do you understand what the diversion program is? Do you understand? Okay, just checking.
Public comment? Thank you. Next will be the enforcement program activity.
Okay, currently through September 30th of this year, we have placed 5 licensees on probation. We had 1 public reprimand, 2 revocations, and 2 surrenders. We filed 7 accusations, withdrew 1. We've got cases initiated at the AG's office at 7, and pending cases are currently 45. Pending cite and fines from last year is 11, and we've collected $1,250 so far of that. And we have currently 52 probationers that are active, and I have 5 that are told. So any questions?
The ones that are told, how long can they remain told before something occurs?
The older ones that are tolling will be on there until forever. They never come off. The new language states that if they don't work for 2 years, their license is canceled.
How does an accusation get withdrawn?
We determined that there wasn't enough to go forward with it, for whatever reason.
Sometimes the evidence that you thought you had falls through, like a witness or an expert, gives some conflicting information about the case or reassesses the case and determines you haven't met your burden with respect to whether someone committed like gross negligence in the performance of medicine. So I think, usually it's evidentiary problems, witness issues, those are common reasons for accusations being withdrawn.
Thank you.
Further questions? Yes.
On the pending cases, there's 45. How long in the process are they? Are they just starting, or are they?
They could be anywhere from just starting to waiting for a hearing. They could be sitting out there for a year or longer. Just depends on the court dates and how they're set up.
And as these progress, are you billed on a regular basis by the AG's office?
We're billed on a monthly basis by the AG's office, yes, as well as our investigative costs.
Okay, thank you.
Further questions? Public comment? Okay. Next item on the agenda is Department of Consumer Affairs, Director's Update. And that comes from Christine Lally. Christine Lally is unable to attend today. She sent me her written report. There are copies of it in the back of the room for anybody that's interested in seeing the entire report. I'm going to summarize briefly some of the more important aspects of it. On September 7th, 2016, Director Canati and the PCA executive staff held its directors meeting with executive officers and board presidents. The purpose of the directors meeting is to update board leadership on the department activities, share important information, and answer questions. Several items contained in the reports were shared during that meeting. I'd like to also add that the director and the head of the legal department individually met with every executive officer and board president over the last couple of months, and they were hour-long meetings, and they were phenomenal. So the other items, that I need to remind everybody of, that Christine was reminding us of, is required board member training. Board members are required to complete orientation training within 1 year of their appointment and reappointment to the board. The final board member orientation for this year will be held on November 16th at the Department of Consumer Affairs in Sacramento. Board members are also required to complete an ethics and sexual harassment prevention and defensive driver training. The reminder regarding required training is emailed to all DCA board members on September 9th, and the email included details on training frequency and registration. If you have any questions, you can call Board and Bureau Relations at 916-574-8214. There are going to be 2 free software releases which will implement requested system changes. One will be deployed on November 16th, and the other will be deployed on January 11th. And we have, the Physician Assistant Board has 6 system changes requests which have been resolved. And so I'm going to conclude Christine's report at this point. Board member questions? Public comment? Okay, we will go on to item number 10, approval of the passing score for 2017 PA initial licensing examination and 2017 dates and locations of PA initial licensing examination. Julie?
This is approval for when, I believe?
Pardon?
Approval of passing scores for 2017.
Yeah.
Call roll. Sorry.
Okay, so there's 2 things that you have to do by law and regulation. The first is to establish a passing score every year for the examination. So the board has adopted a regulation at 1399.507 that basically states that the examination that you've adopted is the National Commission on Certification of Physician Assistants exam. It's a national exam given by a nonprofit organization. All the U.S. states and territories have decided to rely on this examination, so it's a national exam. So one of the difficulties with establishing a score is that this is their examination and they establish the score. So it's one thing I'm probably going to recommend for a future agenda item is that maybe we move this into statute and be done with approving the passing score element every year, because it's a national exam and we really can't do a different score than what the national examination administrators have established. So, however, since we have this legal requirement, we kind of go through the motions every year and do that. So the first motion is to establish the passing score, and the second one is the requirement that you establish the dates and locations. So if you look at your background paper in the agenda items, you'll see that the motion would be, that is requested, is to approve the passing score for the physician assistant initial licensing examination for year 2017 as established by the National Commission on Certification of Physician Assistants. So that would be the requested motion.
I'll make the motion.
Second.
Discussion?
Want me to take roll? Can you take roll?
Charles Alexander,
Aye.
Jennifer Carlquist. Aye. Sonia Early. Aye. Javier Escobar Acosta,
Aye.
Jed Grant,
Aye, but do we have to have public comment on
I
this?
thought you had already taken, I apologize, sorry.
Okay.
Any public comment on this item?
A suggestion for later, and I know this will have to be in statute or regs, is that the language be changed to say the NCCPA or its successor or some kind of language, because they may not always be the certifying body, and that would open it up to other bodies. But that's, I know for future, but something to think about.
Right, we do have a future agenda item at the end of this agenda. That's what I was just trying to give everybody kind of an idea to think about when we get there. We'll talk about it in more detail.
Okay, thank you.
Thank you. Further public comment? Okay, can we continue the roll?
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia,
Aye.
Okay, motion carries.
Okay, so the second motion we need per 3517 of the B&P code, we're required to set the time and place of examination. And again, this is a national exam. We've adopted this examination currently as your examination. And the dates are given on a year-round basis, and the certifying organization indicated that there will be no testing from December 18th through the 31st. So the motion would be for the dates to be given on a year-round basis, with the exception of no testing between December 18th through the 31st, 2016, and the locations would be the Pearson View Professional Center. So that would be your motion.
So moved.
Second. Member comment? Public comment? We call the roll, please.
Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay, motion carries. Next item is going to be schedule of 2017 board meeting dates.
Location.
Pardon?
Dates and locations.
Dates and locations. All right, I don't have time. Okay, I've got that.
And this,
So I guess we have proposed dates and locations. We try not to interfere with the medical board, and also our other counsel has given dates that she would not be available. So we're looking at option one, which would be the following dates of January 9th, April 10th, July 10th, and October 9th. Option two would be January 23rd, April 17th, July 17th, and October 16th. And the reason for the number of days after that is so that if we have any enforcement that has to be dealt with within the 100 days. I sort of was toying with the idea, since we have to comply with one meeting in the south, of considering having it in August at the CAPA meeting in San Diego. And those dates are,
10th through the 13th. It would be the 11th, it would be that Friday, August 11th.
yeah, that one date we need to do on a Friday instead. And that would probably mess everything up for the day count, wouldn't it?
yes, yes.
Yeah.
So that's not gonna fly.
No, it's not gonna work.
Okay, so,
I'll just say option one works the best for me. I don't know, whatever
okay,
other board members or.
option 2 works better for me. That's, I have 2 tax filing dates, April 15th and
Yeah.
October 15th.
Yeah.
Yeah, I prefer option 2 as well.
Okay.
And we checked all these dates so that it's not Mother's Day or any of those other things that I end up getting bagged with later on.
I think we're
They look
fine,
good.
they're, yeah.
Checking last
Here's,
night.
here's a count.
And I mean, if any of the days have to be moved up a few days, it wouldn't be a big issue.
Okay,
To move
so
any up a few days, you know, if you need the April date to be more like,
When is the capital conference?
August
I know what dates.
10th through the 13th.
10 through 13.
yeah.
So you can move some of the dates in one of these options so you're within the 100 days?
You could, but the only thing is that you'd like to have your meetings on Mondays, and that's what I think staff were trying to take into consideration, but it doesn't have to be on a Monday.
Right.
I think that would be a great idea to do it in August around Kappa, cause a lot of us are gonna be there anyway, it saves cost to the state.
I mean, my thoughts were it would give the public members an opportunity to come to the CAP conference, see what goes on at it. And I don't anticipate a large amount of PAs attending our meeting because it would be in conflict with the CME courses that are going on at the same time. But some come, and I think it would give the public members an opportunity to see what goes on in these meetings, which I would think would be very beneficial.
When is the CAP conference?
10th through 13th. So, and Bob's looking at Friday the 11th.
Only because that's when they're to the whole.
Wonder if there's a way we could look into getting like a discounted room rate for room space too at the Sheraton.
Yeah, the state gets a way more discounted rate than Kappa gets. So you would do much better to go directly to the Sheraton and get that rate directly. And I do think there will be PAs who are interested in this process, who would come. You're not gonna get 30 or 50 people there, but you might get some PAs that are really interested to watch how this system works.
So I just wanna make it clear, there's no rule that you have to meet every 100 days. Just so you're clear. The reason the staff are doing this is more for a economy than anything, because if some decision comes up where you only have 100 days to look at your decisions, your disciplinary decisions, then we might have to have another meeting, like a teleconference or something, to discuss that particular disciplinary case. So the staff are just trying to save you money from that perspective of having another meeting. But if it's important for you to have the meeting around conference time, then maybe it'll be worth having an extra, risking, I'm not saying you're going to have an extra meeting, but risking that you might need to have another meeting. So, I mean, you have flexibility in these dates, I don't want you to think you don't, so.
So would option 2 work if we changed Monday, July 17th to Friday, August 11th for everybody? It sounded like option 2 seemed to be the one that was most popular so far.
Judd, do you have any issue with?
That's fine. I can move my calendar.
Do I hear a motion?
I'll make a motion for option 2, except July 17th change to August 9th.
Is it 11?
11.
That's what I meant. I'm sorry, it's August 11th.
I second.
Further discussion? Okay, and the August 11th meeting would be in very Southern California, San Diego.
Yeah.
And the remainder of the meetings in Sacramento. is
The
that-
remainder of the meetings in Sacramento. Okay, public comment?
I would just advise staff to get that space in those rooms reserved as soon as possible
We
at the
will.
Sheraton and make sure that's feasible.
If you will give me the contact information, we'll start working on it next week.
And you may be dealing with it because you're state and I'm association, but I'll give you the hotel contact.
Yeah, and, yeah. That'll work.
Okay.
Okay, do we wanna call the roll then?
Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay, we have our meeting set and location. 2 years in a row we're complying with that. Okay. Uh, Oh, I can do, yeah, we can do number 12 next. Item number 12, discussion and possible action regarding, SB 1083 Paisley, January 2017 implementation of physician assistant authorities to certify, unemployment disabilities certifications. I put this on the agenda so that, we could remind our friends over at Department of Health Services that this needed to be implemented January 1st, and they beat me to the punch, and it has been implemented. You can go online to SBI and register with them, and you will be capable of certifying disability, just like our nurse practitioner colleagues. The only additional advice I will give everyone here and whoever is watching the webcast, the form that you fill out electronically, one of the questions, it asks what your professional status is. There's a drop down and it says physician assistant. The next thing it asks for is your license number. I always just put my license number, never PA in front of it. And it form kept rejecting my application, but it wouldn't tell me why. I ended up having to call. I was fortunate that Lynn gave me a phone number that actually got me to a live person. And the long and the short of it is, in the box where you put your license number, you have to put PA in front of it. And then it goes through in 10 seconds. So it'll save everybody a lot of pain if they just add PA to their license number at the beginning. So this is now a additional step for the profession. Thank you to Kappa, who got Senator Paisley to do this bill for us. It's great. Before I do regulations, I think I am going to go out of order and do item 19, Dr. Bishop's medical board report. And again, assuming part of it. Okay, so the medical board would like to congratulate Lynn Forsythe on her appointment as the board's new executive officer. Medical board staff looks forward to working with Ms. Forsythe in the future and is willing to provide any assistance needed during the transition. The medical board held its quarterly meeting on July 28th and 29th in San Francisco. At the July board meeting, the enforcement committee was provided an extensive presentation on the board's probation unit. Management has been focused on reviewing the policies and procedures for this unit for the consistency and improvement. The presentation also included information on action the medical board would take if an individual violates his or her probation order. The probation unit is expediting actions and pursuing cease practice orders when necessary. In the first quarter of fiscal year 16-17, the board has already issued 13 cease practice orders, which is one less than those issued for the entire 15-16 fiscal year. The Enforcement Committee also heard an update on the board's investigation and vertical enforcement program from the Department of Consumer Affairs Health Quality Investigation Unit and the Attorney General's Office. The committee also received an update on the board's expert reviewer training program and recruitment plans for experts. The board held an expert reviewer training on October 8th, 2016 in San Francisco, and will be providing training on November 2016 in Los Angeles. The goal of the training is to educate experts on their role and functions. The board's expert recruitment plan includes posting information on the board's website homepage and developing a brochure. The board will also be placing a larger article in its newsletter and finding ways to put information into more external organization newsletters and magazines. Lastly, the board is going to be working on a 3-minute video explaining what it means to do an expert and asking physicians to consider assisting the board in its important function. This video will be posted on the board's website, but can also be used to provide to hospitals, physician organizations, and associations to share with physicians. The medical board is continuing its outreach campaign, and as reported in the July board meeting, this campaign currently has the potential for reaching at least 17 million California consumers. The board has now completed production of a brochure in both English and Spanish, and just recently released an online tutorial in both English and Spanish. As previously stated, the goal of the outreach campaign is to encourage consumers to look up their physician on the board's website so they can be an informed patient. At the full board, the members received a presentation on the new End-of-Life Option Act. This presentation was provided by Dr. Gurby, who was the former member of the Oregon Medical Board. He had expertise with the implementation of such a law in Oregon, so his presentation was very valuable. The presentation can be viewed on the board's website. The board also received an update on the board's sunset review process. At its October board meeting, the board will be reviewing the draft report for approval. As previously stated, the board has several new issues that will be included in the report, including requesting a licensee's expiration date to be 2 years from the date of the license issued rather than the physician's birth month, requesting penalties for facilities that do not report as required in Business and Professions Code Section 805.01, and changing the language in the law requiring the posting of a sign in a physician's office. The board also received a presentation from Dr. Catherine Nation, Associate Vice President of the Division of Health Sciences and Services at the University of California Office of the President, who provided information on medical school curriculum changes, how medical schools evaluate applicants, and how they deal with unethical, unprofessional conduct. The board members also approved board staff sending a letter of opposition to the authors of Senate Bill 2493, which is proposed federal legislation entitled the National Defense Authorization Act of 2017. This bill would, for the purpose of reimbursement, licensure, and professional liability, redefine the practice of medicine as occurring at the location of the provider rather than the patient. The board has serious concerns with this bill, which would seriously undermine California's ability to protect healthcare consumers, as the board will have no ability to discipline physicians who are treating patients in California and are licensed in another state. These individuals would not be required to hold the license to practice medicine in California. The bill does not promote consumer protection. Board also heard an update regarding an analysis of the board's process to issue interim suspension orders. It was stated that due to the board's health quality investigation units and the Attorney General's office's focus on making improvements to the process to obtain interim suspension orders, that the board's issuance of these orders increased by 157% from fiscal year 14-15 to 15-16. In addition, the board was able to eliminate 150 days from the processing times. The board will continue to make this process a priority for the board. The medical board will be meeting next on October 27th and 28th in San Diego, where the main focus of the meeting will be to review the board's sunset review report. The board continues to be appreciative of its relationship it has with the Physician Assistant Board. The board offers any assistance it can provide to the Physician Assistant Board with any future issues. That concludes Dr. Bishop's report. Questions from board members? Public comment? There being none.
Medical board presentation, maybe? We take a break and then she can set up for that.
Yes, let's do that. We'll take a 10-minute break, and then we will do the medical board presentation. Agenda is presentation from medical board staff on recruitment, training of medical consultants, and we have Ramona here today, who's gonna make us all smarter. So, please.
Good morning, everyone. My name is Ramona Carrasco, and I'm a staff services manager in the Central Complaint Unit of the Medical Board. I'm here today to talk to you guys about the medical consultant program. I'm going to touch a little bit on the expert program, but I'm going to focus more on what happens in the Central Complaint Unit. Okay? So there are 3 types of experts used by the Medical Board: the Central Complaint Reviewers, the medical consultants employed by the Department of Consumer Affairs, and the medical expert reviewers. Currently, we have about 400 contracted physicians in the Central Complaint Unit. And what we do there is, once the cases have been reviewed and they come back from the medical consultant, it comes back with a rendered decision. So what happens is we have analysts in the office, and in your case, we have one analyst person who works the PA cases. So when that person gets all the information, like they gather all the records and the summary from the physician, they have the complaint, they review all of that, and with the boards, with Lynn and her staff, they decide whether the case actually needs to be reviewed by a medical consultant. Once that decision is rendered, it's given to our staff, and what we do is we take the case and we determine what specialty that physician assistant works under, and then we'll match that with a doctor who's in that same specialty, who we have contracted in our office as a medical consultant. That person gets contacted. They're given information such as who the subject of the complaint is, what the allegations are, what specialty that PA is working under, and then it gets determined whether that consultant knows that person or not, or might have any kind of relationship or any kind of knowledge of that person. If they don't, they'll take the case. We ship those cases out, the original case, to the person who's going to review it. That person does that review and sends it back with a rendered decision. They usually do a memo to explain to us step by step everything they encountered with the records and anything, and it's about the quality of care provided by that PA or the physician, or both. So once it comes back, then the determination is made, and that's when it either continues for investigation, or we close it there in the office. So, that's what we do there. The Central Complaint Reviewers, they're contracted. They assist the boards with determination of no violation. It could be a simple departure, or it could be sent out for investigation. The current requirement right now for our medical consultants is that they have a valid license with no recent complaints or prior discipline, the ability to maintain a high level of confidentiality, the ability to provide objective, unbiased evaluations, the ability to articulate and to legibly document the findings, and our most desirable qualifications are current active practice and have a non-active or retired for fewer than 5 years, and this is just in our central complaint unit, and be board certified and have peer review experience. For the experts, just a little touch on them. They verify license renewal. You have to verify a license and be renewed and current at least 5 years. Verify an ABMS first board certification application, which includes 3 years of practice in that field. A current active practice or have been non-active or retired for less than 5 years. Verify and briefs that the applicant has no recent complaints or prior enforcement disciplinary actions. Medical consultants right now in our office, they don't have like what we call a formal training where we bring them out all together and we provide a training. We do a lot of stuff via email and we talk to them on the phone. They do get a training packet. We do go over that with them. They do get, information regarding how to process, how to read the case. The cases that they review, that's the first review that's done to that particular complaint, and it's all cursory. They're just determining whether the care and treatment that was provided to the patient was appropriate and that there was no negligence. So it's not like the expert is a more higher level where, they have to determine to make sure everything is, they get our report and they take that and they add to it. They do a subject interview, they'll go out and do a site visit if they have to. It could end up where, they end up talking to everybody, the subject, the complainant. So it's more of an investigation gathering to determine if they're going to have to take any type of, legal action against the physician's license. So that's the difference in our office. We do provide feedback to our consultants. We have a couple of doctors in our office who review, for example, when our first time consultant gets a case, they review the actual report done by the consultant to determine, if there's anything that we need to coach them on a little further. But it's very cursory and very just the beginning. It's not anything, really, really detailed. The field office consultants are board certified physicians who work side by side with our investigators to assist in evaluating the case. They may be asked to do the following research, new medical procedures on and/or drug reviews, and comment on medical records. Be present during interviews with physicians to assist the discussion of medical options available to the physician. Write memos, give opinions. If there is a potential violation of the Medical Practice Act, and assist in obtaining medical expert reviewers and medical consultants are occasionally required to testify in court. However, most of these duties are performed in the district office. Physicians employed in the capacity of the civil service employees, they must apply through the state personnel board process, be interviewed and placed on a statewide list. They work various hours on permanent intermittent employees receiving an hourly wage and certain state benefits. Those who are interested in the employment opportunity can contact the board's personnel office. Also in our office, as far as our consultants are concerned, they're a little different in the fact that they, like I said, they do a cursory review and they take several cases at a time, and as far as PAs are concerned, it's a little different for them too because, they're looking at the supervision on top of the fact, the treatment that they provided. So, sometimes we simultaneously will open cases on both the physician who supervised the PA and the PA. And it depends on, what we find in regards to the complaints. So it's, like I said, it's very basic, it's, very cursory, but it's still part of the beginning of the process. Does anybody have any questions? Yes.
I do.
Ask.
Do you have any consultants that are PAs?
We don't at the moment. We used to have them. I just came on board recently, several years ago, and for some reason we didn't have any since. I've asked that question, and I'm going to continue to ask because I don't know the difference as far as budgets are concerned to have, for example, us have the PAs or that the PA committee or the PA board have their own. Yes.
My recollection was that we had some administrative law judges and judges that did not defer to the discretion and the judgment of the PA PA
Okay.
experts, and so,
That's why it's up advocate.
because the other side hired doctors, and physicians and surgeons to testify, the decision from Attorney General's office, prosecutorial branch of your program, the prosecuting attorneys decided that they would forego using PA experts, so.
Yeah, I think maybe we're talking about two different things, or maybe I'm misunderstanding. So,
Okay.
if I understand correctly, please correct me if I'm wrong.
Yes.
But the consultants are reviewing the cases basically to see if there's merit, if they should go on. Is that correct?
Correct.
And then later, experts would become involved, right?
Correct.
So I'm not really so concerned about having a PA as an expert witness.
At
but-
a hearing.
Right, but I'm more concerned about why there are no PAs involved in that initial consultant process on PA cases. Because I don't think that a physician necessarily has the same perspective as a PA would on what happened with the case. And so I understand the need when we're talking about expert witnesses and determining standard of care and that sort of thing. But in the initial review, and the reason that I had questions about this is because we've recently had some cases that were kind of dismissed after a whole big investigation and everything, really weren't found to be very solid. And so I'm wondering if there was a PA consultant involved early in that case, maybe the case might have not made it all the way through because of that different perspective in the beginning. So I wonder if you would have any opinion on that or thoughts as to any difference that there might be in your process if there was a PA consultant involved on PA cases.
Honestly, I couldn't answer that, but in listening to what Christy said, is, that might be the same opinion they might have as far as even our level of review. I don't know. I would have to ask.
I think that might be a case more appropriately directed to the Attorney General's office, and maybe your liaison could address that issue for the board at a future meeting or in correspondence or.
Okay, well, yeah,
share. Because I think that was an Attorney General's office decision. I don't believe it was a recommendation. I don't believe it was necessarily a client-driven issue. I think it was a recommendation, but we can certainly look into that and bring that back to the board in a future meeting.
Yeah, if the decision is not made at the medical board, if this is driven by the Attorney General's office or something, then I think I would like to have that question answered. Because as a PA, if a case came forward, I, as a licensee, would be more comfortable knowing that somewhere in this chain, there is another PA looking at this, rather than only physicians.
Okay. I do agree with that, but like I said, I'm not sure what the history is regarding this and how it's handled. Decisions are made at our level, because if it doesn't go further than us, the consultant who reviews it decides whether it's going to be a violation or it's not.
Right, and that's kind of my main question is, on a PA case, should that consultant be a PA? And if not, why not?
Okay.
Other comments from the board?
I totally agree with Jed, because we were talking about this one case, we're gonna discuss that probably could have been completely avoided.
Okay, we can't talk about closed session.
Right, could have been avoided with PA intervention.
Well, I'm gonna take it back and find out for myself.
That's great, thank you, and thank you for coming to share this process with us.
Oh, yeah,
It's
you're
very,
welcome. You're
helpful
very
to me to
welcome.
know how it works.
Yeah, like I said, we do have one person in our office who handles all the PA complaints and does all the enforcement stuff for PA. So, if you guys ever have any other questions, please do not hesitate to contact us. We're available. Even if it's just a question in regards to the process, things can always be moved around and looked at, and you can be provided an answer so you know what we're doing.
Yeah,
Okay.
I think we're all appreciative of the great support we get from the medical board and our close relationship, so not being critical here at all, just
Oh,
trying to
no,
understand.
that's fine. Yeah, I totally understand too. So that's basically all we do in our office as far as the med consultant program is concerned. It's a really small program. I mean, in our office, like I said, we have 28 to 30 analysts, but they handle all over the state. And we have 2 people who ship the cases out to our consultants, and they're constantly every day talking to all different doctors from all different parts of the state. So, you know, things are always moving, and like I said again, and, you know, and we meet at our office, if there's ever any questions or anything that we can do, you know, answer for you or do for you, just let us know. Okay?
Great.
Thank you for having me.
Thank you.
Thank you. Is there any public comment? Okay. I'd like to welcome Janice Fennell from the USCPA program. Congratulations on your recent victory.
Oh, yeah.
Challenge bowl. We will go to item number 13, regulations. Number A is proposed amendment to Title 16, California Code of Regulations, Section 1399.523, Disciplinary Guidelines Update. Julie Caldwell.
Hi, so I'm giving this report on behalf of Anita Winslow, so if there's any questions or comments, they're better directed towards her since she's responsible for this, but for 1399.523, non-substantive charges, section 100 to the PAB manual disciplinary guidelines and model disciplinary orders was approved by the Office of Administrative Law and filed with the Secretary of State on September 14, 2016. A finalized copy of the guidelines is posted on our website. And we've also put one for each of the board members so you can seats.
Anybody have any questions? Public comment? Okay. Don't go too far. Item D, proposed amendment to Title 16, California Code of Regulations, 1399.546, reporting of physician assistant supervision. Julie Caldwell.
The rulemaking file has been submitted to the Department of Consumer Affairs and the Business Consumer Affairs Services and Housing Agency for review. Once the review is complete, it will be submitted to OAL for approval and filing.
Okay. Further questions? I have a question. Didn't DCA come out with something that the director is going to be doing with all regulations?
Okay, so the rulemaking process is designed to clarify statutes that have interpretive issues that need clarification. And so the process for rulemaking for this board is that you develop your proposal and then you submit it before September of this year. You would approve text and you'd file it with the Office of Administrative Law. And there's some control agencies that look at the package as well in the text to see if it makes sense, if it's fiscally been analyzed properly, if there's any fiscal impact to the regulated community and businesses. And so Department of Finance looks at it, and the State Consumer Services, Business Consumer Services and Housing Agency is the agency above the Department of Consumer Affairs that reviews the fiscal impact statement and signs off on it. If they agree with it, then your package can go forward and be reviewed by the Office of Administrative Law. So in September, the director notified the boards in the department that the process would be changing and there'd be an initial as well as a final review. So before September, you just had a final check of your language and your economic impact statement. Now, before you file it with the Office of Administrative Law, you will have to run it by the control agencies for initial review. Then it's filed with the Office of Administrative Law, and then it will get a secondary review on the back end after public comment period happens. So we don't know if it's gonna take additional time. I anticipate that it will, although the department thinks that it will actually speed things up. We'll kind of have to see. For the packages that you've already filed with the Office of Administrative Law, it will not affect them. It's only the ones that we haven't yet filed with the office that are gonna get this preliminary review. Any questions on that?
Okay, public comment? Okay. Item C, proposed repeal of Title 16, California Code of Regulations, Section 1399.531 and 1399.532, board requirements for approving specialty training for physician assistants. Update Julie Caldwell.
So the rulemaking file to repeal these regulations has been initiated, and we anticipate a hearing for these regulations at our April board meeting.
Board comment?
Great.
Public comment? Okay. Next item, number D. Discussion and possible action to initiate rulemaking to add section 1399.515 to Title 16, California Code of Regulations, retirement status for physician assistant licensees.
Okay, so this one's gonna take a bit, so bear with me. The board has current authority at Business and Professions Code Section 3521.3 to allow people to place their licenses in a retired status. The law was enacted a while ago, and you have not developed regulations to implement it. So this proposal would implement the retired status regulation system for people to place their licenses in a retired status. And in addition, AB 2859 will go into effect January 1st, and it's a department-wide authority to implement retired status regulation. There's been a push for a while now for the boards to implement this because we've received numerous complaints across the department from licensees that want to retire and there is no status for it. Right now, if you don't want to pay a fee, you let your license expire, go delinquent, and lapse, and then after 5 years it's canceled. So nobody likes it when they retire for someone to go up and look them up on the license website and see delinquent, expired, and canceled. It has a negative connotation to it. In addition, there is an inactive status that you can place your license in, but you have to pay a fee to do that, and a lot of people object to that because they say, well, I'm not practicing, so why should I have to pay a fee to just say I'm not practicing, I'm retired. And so for all these arguments, like I said, there's been a push to implement this process, and I believe Ms. Forsyth was telling me that they've received complaints as well from your licensed population. Hence, we have this proposal in front of you, and the idea is to implement your authority at 3521.3, and the statute contains language that requires the board or allows the board to establish by regulation a system for placement of a license in a retired status upon application for a PA who is not actively engaged in practice as a physician assistant or any activity that requires them to be licensed. And the other criteria in the statute are that the licensee cannot engage in any activity for which a license is required, and the board may deny an application if the license is canceled or suspended, revoked, or otherwise restricted. So this retired status license would not be available to people who have a license in any of those statuses currently. In addition, it contains some language that beginning 1 year from the effective date of the regulations, if an applicant's license is delinquent, the board has to deny it. So we have a regulatory proposal in front of you, and I'm going to go over each section really briefly, just so you understand the proposal the staff has come up with. I did make a few last-minute changes. I apologize for the lateness of that. I didn't have time to review it, or I didn't look at it before it went into your packet. So if you look at the agenda item 13 handout that we have currently at the meeting, you'll see some of the additional changes that I suggested to the text and the form that you're going to use for people to sign up for this license. So the proposal is to add a new section to your regulations, section 1399.515, and the subdivision A provision says the board shall issue upon a completed application. So you make it clear that it has to be completed for you to be able to process it. A form, which we've attached as an application here. A retired license to a physician assistant who meets all the following requirements. So the first requirement is they can submit a completed application on the form that you have attached. So if we could all move to the form real quickly. Okay, so you'll see I added some language, and let me explain. Because the statute says, beginning 1 year from the effective date of the regulations adopted pursuant to subdivision A, if an applicant's license is delinquent, the board shall deny an applicant's application for retired status license. So what does that mean? It took me a while to read it over and over again and try to figure it out. But essentially what the statute is asking you to do through regulation is give people a grace period. Once the regulations become effective for 1 year, even if your license is delinquent, you can apply and have the status changed. So what it's intending to allow is people that avail themselves of the opportunity they may not have had when they initially decided to retire, to switch their license status free without having to reinstate their license to an active status. So that's the purpose. The difficulty from a regulatory perspective is how to draft proposed text when you don't know when the regulations are going to be approved by the Office of Administrative Law. So I've come up with some placeholder language, and right now, I know it looks a little weird, but it says prior to, and then I have in parentheses, OAL, insert date, because I don't know when they're going to approve this package, and then they have to add 1 year. So prior to OAL insert date, the effective date plus 1 year, an individual's license may be delinquent when applying for retired status and no fees are required. After OAL insert date, effective date plus 1 year, in order to be eligible for retired license, an individual's license must be in current active or current inactive status. So when this is finalized, I'll give you an example just so it's understandable. So let's just pretend that OAL approves it July 1st, 2017. Then you'd add 1 year, and people would have from July 1st up until July 1st, 2018 to apply for this without paying any fees and get the retired status. So the form would end up looking like this. Prior to July 1st, 2018, an individual's license may be delinquent when applying for retired status and no fees are required. After July 1, 2018, in order to be eligible for retired license, they have to be in an active status, and they have to pay all the fees, reinstate the license, and then they can switch to retired status. Currently, the way this text is drafted, this would be free. You can charge a fee to process this one-time application, but right now, the way it's proposed, there would not be a fee except if you apply later. The fees that would be required to be paid would be to reinstate the license, and then you can switch it. So that's your call. Whether you want to charge a fee, you could legally charge a fee, but the way the staff are proposing it, there's no fee other than if you apply later. And then the rest of the form, I think, is pretty self-explanatory. They have to mail the application in. They may restore their license by, if they apply in that after that grace period, by complying with renewal requirements, submitting proof of completion of CE, submitting a license renewal fee, and a cures fee. Then once they are licensed, then it's clear also that they don't have to pay a renewal fee once they are in retired status. So that's what that form explains to the person that's filling it out. The information that's being required is name, address of record. This information has to be kept current with the board, it's a requirement. Confidential street address if they would like, because we ask for an alternate address that will not be made available to the public in case we need to serve someone or serve paperwork on a physical location. A license number so that we can validate and identify who's applying for it. The expiration date. The last 4 digits of the social and the date of birth are also being requested to validate and authenticate that the person that's applying for this is the person that's licensed by the board. Telephone number, email for contact purposes, it's optional for the email. Then the question, are you actively engaged in practice? That is a legal requirement. You have to ask that question on the application because they're not allowed to apply for this license if they intend on practicing at all in any way. So that has to be asked, and then I added a certification requirement so that, you know, people are truthful and honest in their answers to you. And a signature, and then we have, some additional, internal information that's collected at the bottom for the staff to enter onto the application. Then I've also added, whenever we collect personal information on a form, the California Information Practices Act, which is California's privacy law, requires us to disclose to the people, and that's the next page on the other side, the personal information, what we're collecting, why we're collecting it, our authority for collecting it, how we're going to use the personal information, and where they can locate information that we maintain about them and who they can contact. So I've added that because that, if we don't have that on the application, it's a ground for OAL to reject it, because it's a legal requirement that we have in every form. So those are the things that, were put on the form, and some of the additions that I put on the proposed, form language. So if we go back to the text in the first page, then we have the other criteria besides filling out the form that they have to meet, that they have, they've been licensed for board, not actively engaged in the practice. The applicant's physician assistant license, I've changed it to is not canceled, because it's gotta be presently not canceled or subject to discipline. If they were ever canceled or suspended at an earlier time, that's irrelevant to the analysis, it's just what their current status is. And then sub 3 is again that information regarding, when a person can apply in that grandfather period. It's 1 year from the effective date. It has to be before that time period in order for the person to be able to apply without paying any fees. So if they do not apply during the grace period and they apply later, then I've added some language clarifying what kind of fees that they have to pay in order to qualify for this status. So it says if the license is a delinquent status, the applicant may satisfy this requirement by submitting payment for all outstanding fees with the retirement status application. For the purposes of the subsection, outstanding fees includes all accrued renewal fees, a $25 delinquency fee, and the mandatory fee for cures that they have to pay. So those are the criteria for reinstating from the delinquent status in order to qualify for an a retired status if they apply after the grace period. Then we have the prohibitions for the holder of a retired license that are set forth in sub B, and the process for restoring to an active status. So people can come in and out of the retired status, and sub B3 clarifies what requirements you have for someone if they decide after they're retired that they want to come back to active status. Now, one thing I did notice was missing, and I'll just put it out there, is that some of the boards have put a cap on the number of times people can retire and come in and out of status. And the question is if you want to do that or not. It's your call whether you want to add an additional regulatory requirement like that. I think my accountancy board client capped it at 2 times, and I think dental board 3. So I don't know if medical board has done retired status regulations yet, but that's kind of my experience with this regulatory type process. Any questions? Yes.
On the form, in the third box under address of record,
Yes.
where it says this address is displayed on the PAB website.
Yes.
I think it's not clear which address you're talking about, so
Okay.
maybe if we could change the word this to
The address of record.
the address of record,
Okay.
not the confidential address, because
Right.
it's not clear if you put your confidential address, it seems like that might be the one displayed, so I could see how that would lead to confusion.
Okay. The address. Any other concerns that need to be addressed for the text? Any other proposed changes?
Regarding the fee, question for staff, would it be helpful to restore the cost of processing the request? Would you like for there to be a fee?
We could certainly use it.
Uh-huh.
I, at this point, would have no idea what to charge for it, but we can certainly do some research and talk to legal and get some more information.
I mean, I would not suggest that we have a fee just to have a fee, but if you were to do an analysis and estimate how much time this would take from your staff and what that would actually cost you, it seems to make sense to include that as a one-time fee.
Yeah, I would agree. It just depends on, as you just said, how much time staff is going to be spending on this. It may be just a very simple, we get the forms in, we go in and we change the status online. It may take us 5 minutes. I don't anticipate it taking us much longer than that. We've had quite a few requests for it, but there again, how many are we actually gonna get per month?
Right. And I don't want to suggest holding up this process because I think this is a really great idea. Is this, Lynn, is this an analysis that you have the bandwidth to undertake in the near term?
Right now, what do you think, Julie? No?
I think we're able to handle the
I do too.
workload. I would agree that, a fee maybe is, assessed after the 1 year mark. I think that we put them, physician assistants in an inactive status without a fee. And they can certainly be in that inactive status as long as they, would like. But I don't think it's fair to penalize a PA to be in a retired status because they're choosing to no longer work unless they are not in that grace period. I would agree that maybe that would be an additional PSS, but.
Yeah, it'd be really difficult to say, in the grace period, we're not gonna charge for you to submit this fee and for us to process it versus the people that are applying later. So we can only charge a fee for an application if it's to reimburse the program for the cost of staff processing the app. That's the point of an application fee. So we couldn't waive it for the grace period people. We'd have to charge them for it.
Okay, so I misunderstood, okay.
So, I mean, what I was talking about was that they didn't wanna make people reinstate their license and pay the fees for that.
Oh.
Because it's the delinquent status that is prohibited. The statute is really not as clearly worded as I would like, but it says it's beginning 1 year from the effective date of the regulations. If an applicant's license is delinquent, the board shall deny the application. So what they're saying is that 1 year following the effective date, they can apply in a delinquent status and say, I wanna change it to retired. They don't have to reinstate their license to an active
Understood.
status. So those people who go past the 1 year grace period will have to reinstate, pay the fee for renewal, all their accrued renewal fees, the cures fee, and the delinquency fees, because the law prohibits the board from granting that status to anyone that doesn't have an active license. So what I'm talking about is when you fill out the application and send it in, you have to submit an application fee with it. And the law on application fees is you can only recover a fee that would reimburse the program for the cost of staff time in processing it. It's gonna be a reasonable cost and you have to justify it and do what they call a fee study, which is somebody does a desk audit and they say, here's an application, how long does it take you to process? You time yourself, and then you figure out how much it costs based on an SSA or AGPA salary, and you break it out in a table and you submit it with your rulemaking package to justify the fee that you're setting. So if we're talking about doing that, I would bring this package back with the fee. Because if you just notice it and then add the fee later, you have to do a 45-day notice.
No, thank you
add
for
the
the
fee.
clarification.
So
No.
I think you probably wanna have the fee and the application tight together in one package so you don't have to notice and change your rulemaking package as you're going along. It kind of muddies the rulemaking process, slows things down quite a bit if you add a fee in later after you've started down the track.
And currently, we do
So-
not have a fee assessed for inactive status or CME waiver.
That's
So
interesting,
I-
because most people charge for inactive license, yeah.
It's just,
Everybody I know charges for inactive, and that's why the complaints had come in, because they don't wanna pay an inactive fee when they're not practicing. So, I know for State Bar, you have to pay an inactive.
Our inactive status really only is granting them a waiver on their CME compliance.
Right, they still have to pay the fee for renewal.
Correct.
Yes, that's what I'm talking about. So, The difference is, on a retired status, if there is an application fee, they pay it one time, and then they never have to pay a renewal fee ever again, unless they come back in an active status. So that's the difference. The question is, do you wanna charge for the application when you submit it?
Considering how tight the budget of this board has been in recent years, I would suggest that we at least look at the issue. It may be that the costs are really negligible and can be easily absorbed. It also may be that it does create a fiscal burden, and I would think that we'd want to address that at the outset. So, I would recommend that we direct staff to, before the next board meeting, do this analysis to see how much it would cost, what an appropriate fee would be, and come back at the next board meeting with this regulation application and a recommendation on fee, if any.
Okay.
Is that a
Is that your motion?
Yes, that's a motion. If we need one, that's a motion.
Have a motion, do I have a second?
I have a
second.
question. Oh, sorry.
Yes. Discussion?
Question.
Go ahead.
What's the difference between inactive and retired?
Okay, so an inactive, when you fill out the application for a renewal, you just check the box, inactive, you have to pay the renewal fee. You don't have to do CME, you call it CME, continuing education, you don't have to do that. Retired retired application, so every time you come up for renewal, you pay that fee, even though you're inactive.
Okay.
So retired status, if you charged a fee, they would pay it one time, and then they'd never pay it again, pay another fee again, and they don't have to do CE. So the benefit, obviously, if you plan to just, take your shingle down, never do PA work again, is you just pay that fee one time, if there is one, and that's it. You never have to pay another fee to the physician assistant board. You can still call yourself a PA retired, and then you're fine. So that's the difference.
Thank you.
Sure.
Would you be considered, so you're retired, would you be eliminated from doing expert witness work?
Yes,
Okay, so you need your license.
you need your license to be an expert witness, yes.
Okay. Now, when the retired individual decides he or she is going crazy because they're retired and they wanna come back to work, do they pay just a one-time license fee, or do they have, let's say they've been retired for 4 years, do they have to pay 4 years worth of retirement?
B3 is what you have currently drafted. It says you can restore your license to active status by complying with the renewal requirements set forth in 139514. So that is all the accrued renewal fees since the time you went retired. Proof of completion of CE, so you have to do the CE to get back up to where you were previously, or proof of NCCPA compliance, and you have to pay the mandatory fee for cures. So that's what you currently have as your criteria. You can always change it, but that's the criteria. Remember, we have public protection obligations, so we have to make sure that people are competent when they come out of retirement, and so the competency issue is addressed by the CE. Now, you could have other things in there, other criteria, but I would say this is consistent with the other retired regulations I've seen for other boards. And so I don't think, these regulations are designed to alleviate a concern brought forth by the profession. I don't think you're gonna have any anti-competitive issues in North Carolina consideration, but I do think that if you're gonna do a fee, we need to have the fee study broken out and desk audit done, and I have information I can provide staff of how to do that, what Office of Administrative Law would like to see. And then you can decide at that point, if it's a small amount, maybe waive it, it's your call, it's your program. But I think it's fair to take a look at it, just see what your options are. And does anyone have anyone interested in the other issue I brought up, or not, capping the number of times you can come out of retirement?
I'm not, because it costs them so much money to pay all these back fees to make their license active again.
Okay.
If they wanna do that a lot, that's great.
Alright, sometimes there's concerns if you were retired for 10 or 15 years, and then you come in and out, during that time period, you know, some of the boards had concerns about competency coming in and out over a 10-year period. So that was the only concern that I heard. But if you think it's probably not gonna happen for this profession, then, you know.
Well, if you're requiring the CE, I thought the CE or NCCPA certification sort
Yes.
of.
Well, that's one way to address it, but I
Okay.
just wanted to raise that in case you were interested. But okay. All right, any other questions?
Further questions? Public comment? Can we call the roll, please?
Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay, we will move forward with retirement. Number E, discussion and possible action to amend Title 16, California Code of Regulations, Section 1399-514, renewal of license. Mrs. Christie.
Okay, this one should not take as long. What happened is, back in April of 2016, our meeting that I missed, well, I had another attorney cover the meeting, and there was a discussion regarding subdivision A of 1399.514, and the change that was proposed was changing the criminal conviction disclosure requirements from minor traffic infractions under 300 to under 500, because staff's concern was that many of the infractions that they were seeing were red light violations, because they can be up to $500 sometimes. I think they are now over 300. So in order to eliminate those things that may not be substantially related to the practice of medicine, the board voted at that time to change that number from 300 to 500. The problem is, the Office of Administrative Law likes to see an express delegation to the staff to actually move things along in the rulemaking process. So the reason we're bringing this back to you is to request a motion to kind of close the loop on that delegation, and the motion would be, to approve the proposed regulatory text for section 1399.514, direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing.
So moved.
Thank you.
Exactly what she said. I'll second.
So Mary will second.
Okay.
Yep.
Further discussion? Would this regulation have to go to the minute board at all?
It should not, because this is not involving the scope of practice.
Okay.
And so it's merely changing a disclosure requirement on your applications because of, as I indicated, we're getting a lot of convictions that aren't really related to practice of medicine, and it's a workload and volume issue for staff. And you want to focus on the serious offenses that affect the practice, and that's the point of it. And I think because it's going to alleviate some barriers potentially to applications being reviewed, it will not be an antitrust issue for the board.
Okay. Further comment? Public comment? Can we call the roll, please?
Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay, we will proceed with the regulations, change our application. constructed among ourselves to do the education workforce thing at 1 p.m. because we're gonna have a lot of people coming. We're anticipating. Do you want to do budget update?
Yeah.
Okay, we'll do item number 18, which is budget update.
Okay, in your packets, you have month 13 of our budget report. It shows how we ended our fiscal year. With all of our increasing costs in both our investigative services and our AG line items, we actually ended up this year with 1.69% of our budget left, or a little over $29,000. Any questions, any concerns?
Lots of concerns.
Yeah. Yes, I know, but we were still in the black, and and I'd like to thank our budget analyst, Wilbur. He does an excellent job in helping us keep in line with some of these line items.
Yes. Please, I was waiting.
Well, I know the budget analyst looks at the bottom line.
Yes.
I know that, but for our purposes, it'd be nice to, going into the next fiscal year, if you actually use the year-to-date number as a budget number, so we can start keeping track of actual to budget to see if it's really online. Some of these percentages were, one's a negative 25%. I mean, it just doesn't make any sense. And I know you looked into it, and you said you'd be willing to work with the board to start to establish, and I mean, that'd be an easy fix, to just say the year-to-date for last fiscal year is the budget for the current fiscal year.
Okay, we can ask Wilbur and to do a presentation at the next meeting, and he can address more of your concerns.
Okay.
Okay?
Then the other one is it possible, because this is for period 13, which is the end of the year, is it possible to get a monthly report
Sure.
before the meeting, just so we can?
Yes, we can give you an updated, the actual budget hasn't been set yet, that's why you don't have a
Okay.
current
Right.
one, but as soon as it is, we'll be more than happy to supply you with an updated version.
Okay.
Monthly,
Yeah, we can.
send it out. And are we doing a BCP or?
I need to check with, our budget analyst to see where we are in the process.
I know our enforcement costs are gonna be higher this year than they were last year.
Yes, very, very definitely.
Also, with the workload, I mean, you guys are 3 people doing the job of 5, but presumably at some point we'll hire a couple more people as well.
I hope by January 1st to have both vacant positions filled, but right now on our end, it's a budget savings as well, because we're not putting that money out and we're able to allocate it back to enforcement.
Right, but for this year,
Mhm.
this could be an issue, right, when
Yes.
people start, so is there, well, I guess that's part of the DCP, right?
For enforcement.
Well, not just enforcement, is it gonna include staff costs as well? That's kind of what I'm asking.
We can definitely put that forward to budgets and see what he tells me.
Okay.
Okay?
I think you guys should get paid.
Further questions on the budget? Public comment?
I have one comment. So, I'm gonna bring up something that's probably really unpopular, but you think about how much you're charging for an initial application is really low. $25 for a professional license, and considering your costs are going up, you might wanna take a look at it, because at the end of the day, you and the executive officer are responsible for staying in budget, and if you go over and you blow out your budget, you're liable. So it's really important to make sure that your costs can be either handled now, or you foresee down the road maybe needing to do a fee increase. And you might wanna plan for that and build that in it would be a statutory change, it would not be a regulatory change. And I don't know how popular that's gonna be, but at the end of the day, you know, you have liability exposure, I just wanna make sure you're aware that that is an issue.
Well, one thing is $25 for the application, but then there's a licensing fee that's another $200. So
Right, but we're supposed to be recovering costs for the cost of processing the application, and I don't know if you're capturing that at 25, I'm sure it costs more than $25 to process, for staff to process an application. I mean, there's,
When was that, when's the last time the fees have been looked at?
a long time ago, I think it was actually when we discontinued the supervising physician license, which every supervising physician has to pay $150 every 2 years to supervise a PA. We cut our revenue by about 50 to 60% in order to accomplish that, but it brought us into parity with the nurse practitioners. My concern is if you look at our fund condition, supposedly Governor Brown is going to give us our $1.5 million back next fiscal year.
right,
And that's gonna put us at 22.5 months in
Okay.
reserve.
all right.
If we go to 24, we have to start reverting money back to the licensees, which would be an absolute nightmare.
Okay, well, I just wanna make sure that you're thinking about that you're, you know, that you're aware, and I don't know if all the members who are new are aware that they are liable for the budget, so.
And I mean,
I have a follow-up question. Do we know what the average new app fees are across professional licensing? Other sectors?
I've never seen one this low, but, you know, I haven't done analysis across the department, so you might wanna bring that back.
I'm sure we're one of the best buys in town.
Yes.
But again, it would have to go through the legislature
Yes.
to increase it. There's gonna be, I would suspect, a lot of questions from the legislature. Why do you need $100 increase in your application and licensing fee when you have $3.5 million in your reserve fund? That'd be a tough question to answer.
Well, I just know that some of your cases can run into hundreds of thousands of dollars for some of your discipline cases, so I'm just making you aware of it, keep an eye on it, because, you know, you're liable for the budget being, you know, your expenditures being within budget and not going over budget. So, just raising it so that as an educational piece, I'm not advocating for anything, but just keep your eye on that. And I don't think it would hurt to get updates and get a clear picture on how much it's costing you to process these applications, because that would be some of you actually have to put an argument together for the legislative piece anyway, so why not just get yourself used to preparing that report so that if you come to that point in time where you do need an increase, then you know where you are and why you're doing it. And it doesn't come out of the blue and people aren't surprised or something, you know?
So how is that done to determine that cost? Is it through the thing you mentioned earlier where they time it and?
Yes.
Okay.
Desk audit.
A desk audit?
Yeah.
The 1.5 million that may come back in this fiscal year could go back out in 2 fiscal years if the economy takes a dive again. So I don't think you really can guarantee that that number's always gonna be there. And we found out when we had the other retirement, we were in a deficit, and look how long it took for the budget analyst to decide how much of that reserve you could pull out to use to cover your costs. So I think an analysis of the fee structure would be appropriate, and argument to the legislators is, you know, take a look at the tax structure and change it, and get it up to date, instead of waiting for capital gains to fluctuate up and down. Sorry, but
So in answer to your prior question, it looks like 2012 was the last time the statute was amended. I have to go back and see what the changes were. I don't know if that fee was changed at that point.
I think it's worth an analysis at least, in my view.
We can direct, we don't need a motion for that.
That's a future agenda item, I think.
Okay. I'd like to just defer to our bill going to the legislature asking for an increase in licensing fees.
Licensing fee, it's the application fee, correct, Jim? Yeah, right?
Yes.
Well, it would probably be both.
It doesn't have to be, but
Yeah.
we have to do an analysis to see
Yeah.
whether we need to raise both. But I was just
I-
looking at that $25.
I really think an application fee at 25 is really low. I mean, that's
Yeah.
unheard of in any government agency. So I think it would warrant an analysis, and I'm assuming it's taking more than $25 costing us to process that app. So I think we would have enough background info and evidence to showcase that in the legislative push. And again, not licensing fee, I'm talking about application fee, the actual work that staff is performing.
While I agree, if we are about to get a return of money with 22 months in the bank, I think that the timing is problematic. One, because it makes it harder to make a case for it within the legislature, but also if it's passed and then there's new money coming in, then there's a case for the legislature to remove some of PAB's budget for other elements, because now there's a new source of funding. And so if it may not actually end up in any additional money going into the PAB, and then you lose the opportunity to raise revenue in the future when you need it.
Yeah, I don't think we should do it now. I'm just saying the analysis should be started on and worked upon, like we said. I mean, obviously, this is a one-time windfall that we're gonna get the 1.5 million, but moving forward, we may not get another windfall like that. So I think just looking at it and analyzing it and being prepared for that.
Yeah.
Well, plus the 1.5 million could be taken back.
Exactly.
I think-
You never know.
Right. Just wait for the right time.
Yeah.
Is there a possibility, can you structure a license fee? Let's say it's $25 in 2 years, based on cost of living, it automatically goes up.
I've never seen one like that. I mean, OAL, I've never seen them approve something like that. I've seen them, when agencies get a reversion or other elements in your budget stabilized and they're able to deal with cost impacts on like the AG line item and stuff like that. I've seen them do regulations that allow for, 2 years, 3 years, where they give a break to the licensed, public and a regulated public, and then in situations that it will, like in 3 years later, it'll go back up. So they'll do that kind of thing in regulation. I've seen that, but not cost of living adjustment. There's too much room for argument about what that number would be, and so I don't see how we could ever do a regulation that would do that sort of thing.
So if we ever do go over, like we said, they take away, if we go over, as far as intake?
No, I mean, I don't know that they go take it automatically, but what he's saying is that because they see you have a surplus and there's money that is needed in other areas, there may be
Right,
some borrowing.
reallocation.
Yeah.
So then maybe we can
But we're
implement
talking
that.
about getting just simply our costs back
Yeah.
for work that's done on an application.
And I definitely
So
agree,
that's-
it's not $25.
That's all I was considering, that I know that you have cases that are in litigation right now. And those
Right.
things mean that your costs will go up in that attorney general line item. I just wanted to bring it up. I don't wanna stir up a hornet's nest, but because I know, my job is to let you know when there's a liability issue potentially, I would just recommend maybe you keep this on your agenda for future meetings so that you can keep informed.
Well,
About that?
just a procedural question. Since this is directly related to the budget and we're talking about licensing fees, couldn't we direct the board staff to do that now, or do we have to wait?
I think we need to wait and have it be a future agenda item, but you can put in the future agenda item, you can tell them what you'd like to see when they bring it back. When we get there, I think we have
Yeah.
it the last item on our agenda.
Uh-huh. Okay,
Yeah.
I also think we should be sensitive to workload issues right now.
of course, yeah, of course.
Public comment? Okay,
You want me to do this?
sure. We're gonna do item 16, the world famous North Carolina decision.
we're doing development since the decision. I think we've talked at other meetings about the Supreme Court decision involving antitrust issues for state licensing boards. And so, there's been a lot of different governmental agencies looking at this issue, the Attorney General's office, the FTC, and we also have had, as you've seen, legislation proposed by Senator Hill, wasn't successful, but attempting to address some of the concerns raised by the Supreme Court decision. And at the same time, we have the Little Hoover Commission examining and studying this issue, and their focus has been on occupational licensing barriers that people have complained about, and which kind of was brought forth in the North Carolina case. And so before you, I have the report. The Little Hoover Commission's recommendations often result in legislative proposals, so it's important that we examine these issues and see how it may impact your board going forward. And so if you look at the report, if we start on page 7, is kind of a summary of the different, I think there were 7 different points that the Little Hoover Commission recommendations, 8 recommendations that were made by the Little Hoover Commission. The first recommendation had to do with data collection and demographic analysis of demographic data. You already do this at 3518.1 of the Business and Professions Code. You already collect demographic data, race, gender, other criteria from your licensees. So you're already doing this as part of your board function. The second recommendation had to do with federal funding to analyze further the burdens or barriers placed on those attempting to enter a field or occupation. Doesn't really, apply to you, although they did discuss reciprocity. Recommendation number 3 is something that's come up time and again about reciprocity and allowing all professional licenses to be recognized by the various states. The problem for your profession is there's a delegation of services agreement that kind of limits that mobility type argument. So I'm not really clear how that would impact you if they tried to push a mobility type or reciprocity type requirement. Recommendation 4 was providing additional resources to staff who analyze boards for sunset review. Doesn't really apply to this board necessarily. Recommendation 5, there was a focus on whether some of the current licensing standards are a barrier to licensure, including criminal offender, analysis of criminal offender record information. So when a criminal conviction history is required as part of licensure, which we all do at the department, what effect does that have on people's ability to get licensed? That was something we analyzed. And so the recommendations for that are on page 9. You see the summary at the top. The first recommendation is to post on the website the list of criteria used to evaluate applicants with criminal convictions, so that potential applicants can be better informed about their possibilities of gaining licensure. The other requirement is when background checks are necessary, require them to provide certified court documents instead of manually listing the convictions. Concerns were raised that people who don't understand the questions on the applications were potentially not disclosing everything, could be denied a license for not fully disclosing their criminal history. So that was a recommendation. The third recommendation for that issue was creating informal appeals processes. The Bureau of Security and Investigative Services has a disciplinary review committee, so when the staff initiate discipline, that review of that discipline goes through another committee before it's actually prosecuted and brought before the Bureau. I don't see that really working for your board, but that would be something you could certainly put on an agenda and explore if you were interested in that. There was also some discussion about veterans and whether we're actually, the laws that have been enacted to give, additional consideration to education, training, opportunities for veterans were really working. And so there was an analysis of that. They were recommending that some research studies be done to see if the laws that have been enacted are helping veterans get jobs in various career paths. Recommendation 6, so that was that the study about the recent legislation for veterans. That was recommendation 6. Recommendation 7 was that the legislature should require California colleges and training academies to create bridge education programs for veterans and workers trained outside of California to help them meet educational requirements. And then recommendation 8 was developing intern work and apprenticeship models to provide opportunities for people missing certain qualifications to meet the licensure requirements. So anyway, that's kind of an overview, but there's obviously more detail in here, but those were the high points in the summary that the Little River Commission came up with. Does anyone have any questions? Public comment?
Comment from the board members?
No?
Public?
Okay.
Okay. We didn't see North Carolina on every agenda.
Well, it was it's something that I'd recommended as a standing agenda item only because, there's liability for the board members, and I like to make sure that they're informed of any developments. If there aren't any, then I usually say, no report, but there has been some things to report each time. And I think it's important that the board be at the table to discuss these issues if needed, because any legislative proposals, any case developments could impact, their service to the board, could impact cases in regulations. When you're doing regulations, it's important to look at whether there's an antitrust component, because that is, an area of liability. And so that's why I recommend it be on the agenda, but you and your executive officer set the agenda, so you don't want to see it on there. That's your call.
I don't have a problem seeing
Okay.
it. Jumping around again. We do that test. Catherine, would you and Sonia be prepared to do your legislative update?
Yes, it should take 1 minute.
Please.
Okay.
I'm counting on longer than a minute.
Oh, okay. Well, I can talk really slowly. Basically, nearly all of the bills that we considered throughout this year died in committee or otherwise did not make it to the governor's desk. 2 bills did make it to the governor's desk. The bill that extended the sunset of the physician assistant board, it was signed. Hooray, we live another year. And SB 482, which we had extensive conversations about this year regarding the CARES database, and that bill was signed by the governor as well. Would you like me to tap dance?
Yeah. On the table. Questions from members? Public comment? Okay.
I had a question. What about SB 1155?
It was held. It didn't make it to the governor's desk.
Is it gonna be brought back?
It can't be. So
It can't be.
since this is the end of a 2-year session, all of these bills are now dead. Anything that didn't make it to the governor's office. So we start afresh in
Okay.
December.
Public comment? Okay. Yeah. I think we will go, I think at this time we will go into closed session. And as soon as we get done with closed session, we will break from lunch.
Can we get into this one now? Oh, yeah. Yeah, they do. So we can open it up, that's easy.
I guess we're gonna take a 10-minute recess first, and then we will go in closed session at 11 o'clock.
I was just asking.
And your eyes are yellow.
Are we coming back time certain at 1, or is that, can we push that earlier?
I think 1 o'clock is when you told them to
Yeah.
come, right?
Yes,
So we'll need to be back at 1.
we have several guests arriving at 1 to discuss item number 15.
Okay.
We'll call the position assistant board back to order. We're missing one, but he'll show up. So we're gonna go to item 15, which is Education Workforce Development Advisory Committee. And this will be Jed Grant and Dr. Alexander. First, I would like, if purely on a voluntary basis, if the members of the audience would like to introduce themselves for all of the new members here.
I'm Greg Manning. I'm a practicing physician assistant and also associate director of the Marshall B. Ketchum University Physician Assistant Program here in Fullerton, California.
Teresa Anderson, I'm the Public Policy Director with California Academy of PAs.
Gabe Raymond, I'm the Executive Director of California Academy of PAs.
My name is Sandra Feynman. I am the Director of the Clinical Education at Marshall B. Ketchum University.
I'm Judy Ortiz. I'm the Director of the Marshall B. Ketchum University PA program.
I'm Heather Ontiveros, the Clinical Coordinator at Cal Baptist University PA program.
My name is Roy Gazzetto. I'm a practicing PA. I'm the Department Chair for the Western University of Health Sciences. I'm currently the CAPA President.
I'm Janice Trammell. I'm the Director of Clinical Education at the USC Physician Assistant Program and practice part-time as a physician assistant.
My name is Michael DeRosa. I'm Chair of the Santa Maria University Physician Assistant Department in Oakland. I'm practicing PA. I'm a member of the Government Relations and External Affairs Council of PAEA.
Okay, thank you all for coming. Thank you, Judy, for the use of the facility. All right, Mr. Grant, I will turn it over to you.
Okay, so there are 210 PA programs in the United States. 13 of those are in California. 8 of those programs are located in the greater Los Angeles area. 3 of them are located in the Bay Area. And 2 are located in Sacramento. And all of those programs are accredited, either provisional or regular continued accreditation. Provisional program is a status given to new programs, and of those 13, 6 of those are provisional, so fairly high number of newer programs. And there are 2 developing programs in California still. So if we look at the number of programs in California, we have 13 now. In a relatively short time, we'll have 15. Currently, with the 13 accredited programs, California has the capacity to train 569 PAs per year, or graduating class based on their number of seats. And with the 2 additional programs, if they're accredited, that number would go to 613 per year. The average cost of a PA program varies fairly widely, but if you average them all together, it's about $97,000 for the cost of a program. So one of the things we wanted to talk about today was some legislation that was passed in Georgia to address a limited number of preceptors available. So one of the limiting factors for PA education is clinical sites, and a number of preceptors in Georgia address this by creating a tax incentive. Some places in parts of our country, it's common to have programs paying preceptors, and that cost is generally then passed along to PA students. With the cost already at around $97,000, that additional cost is something that might be nice to avoid. The national average for preceptors that are paid is about 33%. Anecdotally, that's less in California. Don't know what the exact percentage is, but quite a bit less than that anecdotally. as most programs in California don't pay preceptors, or if they do, only on a very limited basis. Some out-of-state programs have been paying sites in California, basically displacing students from California programs, which is a problem because we know that most students, if they train where they're from, they tend to stay there. So particularly in areas that are rural or have a high healthcare need, if we can train students from there, they tend to stay there and help with the access to care. And so when out-of-state schools come in and buy those sites up, it limits our ability to retain providers in California, which becomes an access to care issue. The average payment to preceptors by out-of-state schools nationally, by schools nationally, is about $1,000 per student per rotation, which gives a net increased cost to students somewhere between $8,000 and $12,000 per year for their education total. In Georgia, to get around this, they passed a tax incentive that gave preceptors who are not otherwise being paid $1,000 per student up to $10,000 a year tax rebate if they're training either MD, DO, NP, or PA students. In looking at Georgia's numbers for how this has worked out, they passed this legislation in 2014. About 68% of the people who've taken advantage of this tax incentive program have been MD and DO students. 11% of those who have received funding for it are NP students, and about 21% are PA students. There's been about 612 preceptors that have enrolled in the program, and the state of Georgia has granted $816,000 in tax incentives. Similar laws have been passed in both Colorado and Maryland for the same reasons. Alabama, Kentucky, and South Carolina all have attempted similar legislation, but were unsuccessful. So what we wanted to do today was see if we could hear from some stakeholders as to what they think about the Georgia legislation, whether or not it would be helpful in California, and if this is something that maybe the PA board can help with. So with that is my presentation. Any comments from members of the board? Or?
You want to hear more from stakeholders first before the board members? Okay, why don't we have stakeholders comment? Please come up and again state your name, speak into the microphone.
Thanks, Ted. Thanks to the board for the opportunity to speak to you today. My name is Michael DeRosa. Again, I'm chair of the Sangomar University PA program. I've been a faculty member there since its inception in 1999. I would just like to add that the availability of high quality preceptors, A, is obviously important for the training of PAs to provide excellent care. B, is probably the single greatest impediment to expanding our numbers in the state of California. As one of those programs that constantly butts up against schools from out of state who are paying preceptors, and we don't, and we're proud of the fact that we don't. I am in strong support of this measure. I'd also like to reinforce the notion that this only be applied to preceptors who are taking California students, and that it not be available to preceptors that accept other forms of payment. I think those are imperatives if this is to be effective for us. And again, I thank you for your time and your attention.
Thank you.
Good afternoon. My name is Greg Manny. Again, I'm the Assistant Director at Marshall B. Ketchum University and a practicing PA. And I want to first thank the board for taking this task on. We definitely need to start looking at how we're going to train students in today's environment. background with respect to some of the problems we're having is that with integrated delivery systems, you now have one consolidated mass that where you had 60 private practices to take students. So we're feeling the crunch in education to train our students, and we do need some form of ability to give these preceptors a chance to want to step up and start seeing and training students. The one thing that I don't know about the Georgia legislation, and I've been trying to follow it closely, is there a change? Are the preceptors that signed up, were they already preceptors before? And are we gaining ground? What's happening in California beyond just the consolidation of programs are things like Kaiser, who instead of utilizing the medical schools and training programs, are now just sort of starting to move forward to make their own widgets, for want of a better term. And will that mean that Kaiser will only be Kaiser medical students and Kaiser University students? So we're facing a daunting task as we look forward, as we continue to expand our programs and our profession. So this is a great start, and I want to echo the words of Mr. DeRosa, which is, if we are going to push for tax incentives, it should be for trained students from California in California programs. And it also should be specific to preceptors that aren't receiving other types of compensation. But it would be nice to see California also take the lead to try to look for a larger and more global solution as we try to move forward, rather than copying some of the stuff that's coming out of the other states. And I do understand the board's not really poised to take on federal legislation or federal mandates, but I think California tends to be a leader across the country in all sorts of other types of legislation and processes. And this may be something where if we're going to look at this and design something, perhaps we can dream big and come up with something bigger. So I want to thank the board for letting me address you.
Thank you. Any more public comment?
Hi, my name is Roy Gazzato. I'm the program director for Western University, also the president for Kappa. At this point, I want to let you know, as a program director point of view, that this does directly affect our students. We do have a big county hospital site that we've lost sites to because of a foreign medical school coming in and paying $1,500 a month per student, whether they're there or not. Just like Judd said, these students, our students in California, will go back to the places that they've been trained in. That's what the studies show. We really want to keep that. We want to keep our students in California. I concur with all the rest of the speakers. This is monumental. This is forward thinking. This is something that could really do something really nice for the preceptors, PAs, and students in California. So thank you for letting us address this to you. And thank you for having the courage to make this one of your visions. Thank you so much.
Hello, again, I'm Janice Trammell with the USC Physician Assistant Program, and the Director of Clinical Education. And in my role, I'm constantly seeking out additional clinical sites for our students that are of good quality. And one of the barriers that we're experiencing is when we want to place our students at federally qualified health centers, there's a disincentive because the sites are reimbursed based on numbers of patients seen, and they view having a PA student as a interference with productivity, when in actuality that's not always the case. But a measure like this that will support the training of PA students in these FQHCs would go a long way towards allowing the FQHCs to recruit graduates to work in those areas which are definitely underserved, and they have a big challenge in reaching out to PAs and recruiting them. So the best way to recruit an employee is to train a student. They get to know the student gets to know the site. And it's just sort of a win-win situation. But the revenue, they can't afford to have a reduction in revenue based on taking PA students, so that is a barrier. So this this measure would go a long way to support that activity. Thank you.
Good afternoon. My name is Sarah Feynman, and I am the director of the clinical education for the PA program at Marshall B. Ketchum. And just to echo what my colleagues have said, I'm in the role where I'm getting preceptors on a daily basis to join this mission that we have on educating the future of our healthcare PAs. And when we do get a quality preceptor, it is nice to keep them engaged. It is nice to give them some type of incentive to maintain them, because longevity and consistency between our preceptors is important as well. So just to add a little bit of the longevity to our preceptors, would be able to incorporate the positive, and that maybe the tax benefit is one of them, but definitely echoing what my colleagues have said, that I think there's something needs to be done to help our preceptors maintain the engagement. Thank you.
Just out of curiosity, if I could ask, with the number of programs in Southern California, has there been problems getting and retaining clinical sites due to competition? Has there been problems, like Roy mentioned, with out of state or out of country, in the case that he mentioned, people paying for clinical sites and displacing your students? Is that a common problem?
Can I speak from here?
Yes.
If you talk real loud, because he's recording it, I think.
I think one of the public hospitals that Roy might have been alluding to, they would take men in their OBGYN department, and when this non-US program started paying for students, then our students were kicked out. And so we want to make sure that we have good diversity in terms of our student body, and we want men in our profession, but some of the clinical categories are very challenging, and so we lost our ability to have male students in an OBGYN setting. And it's a direct impact of the offshore programs paying for sites.
The interesting prospect of that is that these are publicly funded institutions that are publicly funded by state dollars and also by local dollars as well. And our local universities, contribute to those funds, and yet we don't really have access. So in this, it'd be nice to look at some form of legislation about mandates of at least the public institutions helping train local students. Directly to your question, one of the issues that we haven't confronted just yet is when all of the programs are online and out in the clinical rotations, then I think we are all going to feel some pain. To date, right now, we don't have all of the programs up and running, and certainly they're not all out looking at clinical rotations, but they are out there looking for clinical sites. And I do know that we've come into contact with sites where some programs who are willing to pay for the money, or pay for the training, are getting precedence over those perhaps that don't. And so we're feeling a little bit of it, but I think we're staring down the barrel of a gun on when we're all up and running with all of our students.
Well, like I said, I'm from a Northern California program, but I would say that it's a weekly issue for us to deal with a local competitor who's got a DO program that's paying for sites, so the PA program's kind of forced to do it. Out-of-state schools that are paying for sites in California, and then the offshore medical schools. It's one or the other almost every week.
Other public comments?
All right.
All right, well.
Board members?
Jed, why don't you take the lead on what solutions you may have in mind?
Well, the question with this is this really fall under the purview of the board. Our mission is public safety. And you can make the argument to some extent that if there's no access to care, that is a danger to the public. So I think that it is something that it's good for us to talk about, and I think it would be good for us to be mindful of it and perhaps work on moving this forward. I think right now is a difficult time because we're short-staffed Extremely, and we have some budget issues, so, just some things to think about. I think clearly there's an issue. I think that this is one way, like Greg talked about, this is one way of looking at this issue, and I know that there's other funds available through grants and scholarships and things like that to help repay loans that students take out. The public fund aspect of it is something I didn't really think about. You know, you're taking public funds, you should be held to a little bit of responsibility for taking local folks because of that. The thing that worries me a little bit is, you know, we could put together some probably good legislation, you know, that we think would be great and find a sponsor, but you know, even at 613 PA students, if each one of those preceptors are taking $10,000 a year, that's $6 million. And if you look at all of the MD and DO students that would be covered under this, and also NP students, you're getting into the tens of millions of dollars, maybe even hundreds of millions pretty quickly. And so I'm not sure that there's going to be good support for that. And, you know, really look to Catherine. I would be interested to hear, you know, what you think about this and sort of options where this could go. In terms of cost, I mean, I think it would be great to put this together, but if it's never going to see the light of day, then maybe we should focus our efforts on different things.
Well, I want to start first with really appreciating that you brought the issue to the board, and so appreciating the time that everyone spent to share information from us. Even just this short conversation was incredibly illuminating for me, and I imagine for other members as well. I think it really advanced our thinking that we've had in the last couple of board meetings on this issue. I think that there are challenges that this bill would face in the legislature as it looked in Georgia. It would face in our legislature in California for a number of reasons that we've talked about in past board meetings. What I'm hearing though is that we haven't fully identified what are all of the drivers of this problem, and what exactly would be solutions that would change behavior. I think we need to understand both of those things, as well as getting into the cost issue. How much would a bill cost per new PA trained that actually resulted in a new PA trained? I think the legislature would want to know answers to those questions before advancing a bill that already is kind of unlikely to pass because it's a new tax break, which are rarely passed in California. So one possible suggestion for us to think about is to seek a study to learn these things. And given where we are in staffing right now, you know, I don't know that it's necessarily appropriate to expect our staff to do that, but there are plenty of studied bills that the legislature passes. So we could go to an interested legislator and ask them to pass a bill that would mandate the study. And it could be that the study is located at PAB and they give resources for a consultant to produce it in, you know, hand in hand with our staff. It could be that some other legislative body handles a study like that. But that might be a first place to start, because it could identify, not only it could answer the questions that we just talked about, but it also could identify other solutions to the problem, that the dreaming big that I think was a suggestion here. So it's one idea to share.
I did look to see if Georgia had published any data to see if this was effective or not. And there really isn't. They gave a report about their numbers and said they want to reach out to NP and PA programs more. But they didn't really talk about whether or not there were more preceptors or the preceptors were taking more students or anything like that in what I could find. And the AAP, I contacted the AAPA, and they basically said the same thing, which was, you know, there will be information forthcoming from Georgia about efficacy, but there isn't anything published right now. Define the problem and then look for solutions, right?
In the Georgia legislation, did they specify paid preceptors? Were the preceptors getting the tax break, or was it the practice getting the tax break?
I don't think it's, I think it's to the preceptor. I don't have the legislation in front of me, but my understanding from, obviously I'm not an attorney, so, but my understanding is that it went to the preceptor, not in practice.
That's right.
Okay.
Has anyone reached out to the medical board of California? So if this is gonna benefit them, are they thinking the same thing, or are they not?
We discussed it at a prior board meeting with a member of our board who is also on the medical board. There's a lot of graduate medical education money available. I think this is more the issue with medical clerkships when students are in medical school. And I'm not sure, to answer your question directly, no, we have not reached out about that. We did discuss a little bit, but we have not really gotten definitive answers on that. I did speak to one person who's a program director at an NPPA program in California who talked to the state organization for nurse practitioners, who said they'd be interested in working with PAs on a bill about this. It's an issue for them too, I guess. Other comments, suggestions?
I'd like to say on behalf of one of the local medical schools, I think that they are experiencing similar situations. And they are just now starting to think about having to pay for students, which they've never had to do that in the past. So I think it probably affects all of us.
I'd just like to add, Washington, 2 quick comments on the public safety issue. We're a small program. We have 44 students, as you saw in your handout. Maybe some of the bigger programs, like Roy's, could speak to this greater. We produce 400 rotations a year. At the numbers you quoted, we're looking at $400,000 to $600,000 in additional cost a year that I guarantee will be directly passed down to our students. And that will make it more difficult to train disadvantaged students and students from disadvantaged backgrounds that we want to go back into those communities and provide excellent care. So I think it is a very clear issue of public safety. The other comment I'd like to make in introduction, I said I'm a member of the Government Relations and External Affairs Council and Physician Assistant Education Association. I can't speak for that organization today, but I would encourage you, if you go the study route, as the keepers of data around PA education nationally, there would likely be some support there for any kind of study you wanted to do or outreach to Georgia or other states who've done this.
Great. Xavier's our accountant on the board. Any thoughts on this?
No, I think Catherine gave a good outline, maybe of the way to go. But I don't know, would this board do it, or would be the community doing it?
I mean, there are different ways to do it. One, if we wanted to go the legislative route, we could sponsor a bill that the legislature would pass and presumably fund to pay for it to be conducted by, could be conducted by this board, it could be conducted by I mean, all sorts of different governmental organizations. Another option could be for us to say, let's just get this done quickly and ask the staff to work with stakeholders in the field to pull the report together. That would be without resources.
Well, I think the challenge would be, the cost and how it goes into the budget for the state of California. And there's so many other things going on and pressures on the budget. I think that's the biggest issue.
Just to throw out one more idea, since we're brainstorming here, we could send this as a project to a graduate school of public policy where they have for their term projects they have to solve a problem like this or research a problem like this, and and then maybe I don't know if we can even do this, but typically they're paid some small stipend, a few $1,000s to perform a study like this. It's another route.
Well, as a PA board members, I'm seeing like it's going to be a big challenge trying to pass these because all these, you know, we're going to try to save some money for the PA or all the preceptors, but also at the same time, we're not going to, or the state is not going to get this amount of money, and we may lose in some other areas. But as a preceptor, and I precept probably like 2 or 4 different programs in North California, so I know it's a big challenge. They're contacting me all the time, trying to find out how to put their students into the clinics, and for me it's been a challenge for the last 6 years, trying to accommodate different students, and a lot of the MDs, PAs, DOs, NPs, sometimes they're saying I want to take a student because it's going to decrease my productivity and I'm not going to get my bonus at the end of the year. So sometimes it's just a bonus of $1,000, $2,000, $3,000, but this type of help and support, I'm pretty sure it will open a lot of doors for those programs in all California. So the MDs, PAs, and NPs, they can start grabbing more students. And so I think if it becomes a big challenge, I think we need to start working into some other type of incentives to help all the PA programs. And I know like some of the programs, they have already some incentives for the PAs and MPs and MDs. So, and that's very helpful. Like they provide some CMEs, and they provide access to up-to-date and some of these expensive websites from medical education and medical research. So that's some great help. But this type of support, that the one that you brought and that we're trying to share from your copy from Georgia, I think it will be an extra help and extra support.
You know, I'm just thinking about the way we solve other problems in medicine, and I think that we need to maybe address this from a different angle. You have to think about people have a bucket of money, and they have to prioritize how they're going to spend it. So maybe we need to elevate the priority level by getting the word out, and we start making some noise. I mean, obviously we can all support that there's going to be a crisis. We see this iceberg, right? Tip the iceberg. So if we mobilize our PA forces and maybe get like other medical professionals on board that are going to be facing the same issue, and we make it a priority by making a noise about it, that might be another way we could kind of approach it, make it more important. Get it on the radar, so to speak. And this was a good step today, but coming to the board, but I think we need to, like you said, go big.
You know, I would follow in the footsteps of Catherine in terms of getting someone to do research or a project on this. I know that the Health Force Center at UCSF does a lot of this kind of work, and some of it's done just through their own internal grant process. So this could be a way of looking at an issue and presenting an issue to them that they would probably undertake. But given the growth of these programs, I mean, I don't believe they're looking at PA programs, but I know it's an area of concern, particularly as it relates to access to care.
Is there a legislative any sort of subcommittee or anything that a select committee that is designed to look at similar issues? Do we know if
In the
there's any
legislature,
do you know what select committee might look at something like this?
There's one on health workforce.
On the health workforce.
Yeah.
So, I mean, that's another option, is we could ask the select committee on healthcare workforce to hold a hearing on this, and they can hold a day-long hearing where they do, raise the issue, bring in a lot of these voices, and out of that, we could ask for them to publish a report from there.
That sounds great.
We did that 4 years ago. In front of the health workforce, we talked about the issues, and the number one barrier at that time was rotations, and actually you were present for that and gave testimony in front of that select committee. So, to bring it back to them is probably a good idea, sort of keep it in the forefront of their mind.
But that didn't generate the kind of research that would be necessary to move this issue forward?
there was a state action plan that was done. There was the Health Workforce Development Council that was advisory, and through the Workforce Investment Board, but I mean, there's money. You know, when we come back to where is the problem, it's how do you fund these, how do you fund it? How do you get the rotations to agree to it? How, you know, there's barriers, and that was the #1 barrier that was identified. And so people are asking for solutions. We have to come up with a real tangible ask to be able to go to the legislature and say, fix this, fix what? How do we fix it? So it's a balance of finding what that solution really looks like.
Yeah. And I appreciate that. I mean, sometimes these solutions do come out of those hearings, but it sounds like that's at a state where it might be more helpful to actually go to them with a report and then perhaps have a hearing to further flesh it out and get their interest.
But come to them with tangible asks.
Right. From I mean, recommendations from
Right.
from a report. Yeah.
Like Teresa said, that did happen 4 years ago, and we did make the recommendation that would be to try to reduce barriers to PA training in the state. The Georgia legislation that we're modeling this effort off of came in the interim. It came after that time. So this is kind of bringing the issue back, because now there is a tangible thing that has happened now in 3 states that we might be able to mirror.
And were there, in that report, were there other specific ideas, like the idea presented about requiring that public institutions to, to participate in greater number and train more PAs, or other specific ideas that they could act upon?
One specific recommendation that we made back then was that Song Brown consider funding clinics rather than training programs with a portion of their resources for the purpose of training PAs and NPs, so that in order to get access to that funding, they would have to train our students. And that was a specific thing that we recommended at the time.
Would it be appropriate for the board staff to contact this committee and share what we've learned today from the programs and ask them to hold a hearing? Is that appropriate?
I think before you ask them to hold a hearing, I think you want to ask them for a brainstorm to talk through this and just talk about, where we're at, where the discussion has been, that we see a number of routes ahead, that there's, interest in this policy idea, there's, questions about whether we should, conduct or support some sort of study to collect more data and what that would be, or are we ready to, to go to a hearing and start to flesh this out in front of the legislature. And I think, so that might be the next step, is just to have that conversation with whoever is chairing that or staffing that committee, and work in partnership with them to move it forward and get their counsel.
So would that require a motion or what?
The problem is the agenda item was next steps in seeking possible legislation to offer tax deductions for preceptors, and so I don't know.
That's what we're trying to figure out. What's the next step?
Lines.
If the next step would be to contact this subcommittee and then.
Right, but I don't think you want to take a motion on, it's not really noticed for that idea, taking it to a, it's not for tax preceptor purposes, it's for exploring a study, isn't that what you were talking about?
No, well,
Ms.
maybe.
Hazelton, were you?
Well, it could
Study
be.
to see if
It
the
could be
tax-
to have a broad-based conversation that could include, say, this is an issue we've addressed, there are a number of possible solutions, there's this legislative idea, there's, the sense that we could,
Right.
look for broader ideas, what have you, so it could include it in that.
Unfortunately, it's, the agenda item is pretty narrow, it talks about tax deductions for preceptors only.
But we don't need a motion in order to have a
So
meeting.
if the staff understands what the discussion entailed today, they can just bring this back in a future agenda item and report on, exploring that issue with what's the name of the committee?
The Select Committee on the Healthcare Workforce? Is that right?
Select Committee on Healthcare Workforce at the next board meeting.
But would we need a motion to send a delegation to meet with them?
Can we just
The
direct
problem-
staff to do it?
No, I wouldn't do a motion on this one because the agenda item
Right.
says seeking possible legislation to offer tax deductions for preceptors, so.
I understand that, Chrissy. What I'm asking is, can we act without a motion?
I think what you can do is ask staff to bring this item back to the next board meeting, understanding the discussion and the scope of what occurred at this particular meeting.
And allow them to
And
figure
allow them
out
to figure
what
it out.
needs to be done in advance of the
Otherwise,
conversation.
you would have to wait to the next board meeting to give them specific instructions, and committees and subcommittees and delegations would have to be voted on at that meeting.
Got it, but Jed, as chair of his subcommittee, could go and start having conversations if he wanted to, right?
No, because
So-
that goes beyond the original concept of what this advisory committee was for, I think, so.
Well, it's the Education and Workforce Subcommittee, right? I mean, isn't that the name of it?
Right, but the task wasn't delegated to you specifically to do that work for this particular committee. So, like I said, I think the best legal option, considering the limitations of your agenda, would be to have staff report back on what they have done to explore that concept and come back with concrete asks or steps that the board can take with respect to this issue, and then you can discuss it at your next board meeting.
So I guess I'm a little bit, maybe I'm just not understanding, but, I think that this legislation is one idea, and it needs to get to the legislature to go somewhere. So since that was our agenda item, could we not talk to this select committee in the legislature and try and make that happen?
If that's the only issue you wanna discuss with them is proposed legislation, that's fine. But I heard other ideas that you wanted to circulate with this committee that goes beyond the agenda item that's listed here. So
So-
that's what I was talking about. So if you're only asking staff to meet to discuss the tax deduction idea, that's fine, you can do that and do a motion at this meeting. But if you're asking them to explore other ideas like studies or other pathways to address these issues, then I would ask that you put it on another agenda.
Well, rather than have a 3-month delay to meet with this, I mean, and I'm not trying to get around the law here, I'm just trying to understand what we're doing. It seems like talking to this committee would be the right thing to do. And if this legislation isn't, this is the idea we had, but if they want us to do something else, then that can come out of that meeting. But waiting another 3 months to talk about having a meeting that we already know we need to have seems kind of.
Well, you don't have to wait to have another meeting. You can always do a teleconference meeting between now and your next January board meeting. So you don't ever have to wait to have another meeting.
No, no.
Only 10 days you would have to wait.
What I'm trying to say is I don't see the conflict with this agenda item. It seems to fit to me. Am I misunderstanding?
I guess, I don't know, I mean, maybe I'm talking crossways at you, but what I'm saying is because the law requires us only to take action on items that are specifically listed on the agenda, to go beyond the tax preceptor issue, deduction issue for preceptors, to discuss other things, if you're gonna do a motion that would include that, that would be, in my mind, beyond the scope of what's listed here for you to do and give specific direction on. So that's why I'm saying if the only thing that you're asking staff to discuss with this committee is tax deductions for preceptors, that's fine, you can direct them to do that and bring that information back to the next board meeting. But if you're asking them to discuss other options, that's something that you would probably need to put on a future agenda item.
Can we ask staff and our subcommittee to prepare for this to be on the January agenda and do what they need to do, the conversations they need to have to prepare for that to be on the next agenda?
No, because your agenda item was for tax deductions for preceptors, not other items. So delegating them other tasks would be an action that's not listed on the agenda.
Okay,
I have a question.
Okay.
If we make a motion just for the tax issue, and they go to the committee, and the committee then says, is there any other method to get to this? It's not us, it's the committee that's starting to ask questions.
Well, you can, the problem you're putting me in is you're asking me to say that it's okay to discuss something beyond what's
No,
listed
not us.
here.
Them.
I understand that. We have no control over what the committee does.
Right.
But asking staff to say what they think you might think is, I think, putting staff in a difficult situation. That's why when we list these items on the agenda, you need to be broader, so you can discuss other things besides what you have here. So it should have said tax deductions for preceptors and other options for resolving the workforce health, shortage of workforce issues, or whatever you want to talk, discuss it.
Like
The
a
problem,
standard disclaimer.
the problem is that, your staff can't tell them what you think they might be because you haven't given them direction to discuss that at this meeting. All they can say is, we'll have to get back to you on that because the board hasn't taken an official position on what it thinks those items might be. So that's why, I get kind of conservative on this because there's civil and criminal penalties associated with non-compliance with the agenda issues. And so I would recommend that if you want this to be discussed before the next January board meeting, do a short teleconference meeting where you discuss all of these options, all the things you'd like to vet with this committee. Delegate it to the two-person advisory committee or delegate it to staff to meet and discuss with the committee and the legislature. That would be my recommendation.
Teleconferences don't work, number one. Number two, regardless of what we put on the agenda, it's not gonna mean what you want it to mean.
Oh, no, it could. It could have
But it
said,
doesn't.
in
The
seeking
his-
possible
okay,
legislation
but
to address, and it
The
would
history
be
has been,
broader.
regardless of what we have on the agenda, it's always, no, it has to wait till the next agenda.
So how about this?
That's, no, I would disagree with that assessment, but.
Will
in
this
any
work
event-
since the specific issue is tax breaks for preceptors based on the Georgia legislation?
Sure.
Would it be okay for me and board staff to contact this committee to ask them about this specific issue that's
Yes,
listed on this?
yes,
agenda?
that's
Okay.
fine.
So how about we do that and report back the next meeting?
That would be fine.
Okay, we don't need a motion for that, correct?
I think you do need a motion.
Okay.
Okay, so moved.
Second.
Do I have a second?
Yes.
Further discussion? Public comment? Julie, will you call the roll, please?
Sure. Charles Alexander.
Aye.
Jennifer Carlquist. Aye. Sonia Early. Aye. Xavier Escobar Acosta.
Aye.
I did it again, I apologize. Javier Escobar Acosta.
Aye.
Jed Grant.
Aye.
Catherine Hazelton.
Aye.
Xavier Martinez.
Aye.
Robert Sachs.
Aye.
Mary Valencia.
Aye.
Okay, so motion carries.
Can I ask about a second motion? In directing the staff to bring this back to the next agenda and prepare for us to discuss this in the next agenda, could we suggest that they consider, explore what possible options might be for entities that could do a study that would be helpful here?
Well, I think your staff will prepare the background paper, you don't need to do a motion on that. That's what I was trying to
Yeah.
advocate at the beginning, just
Right.
if they understand the discussion, they'll come back with a paper. And
Right.
just leave it at that and not do any motion.
Although we haven't discussed that particular idea, that we do a bit of a field scan to see, which graduate schools might be interested, which academic institutions might be interested, which others, there might be stakeholder groups that would be interested in doing such a study. So it would just be helpful to have that information going in so that we could get moving next time.
Okay, do you understand what she wants? Do you understand the scope of what they're asking?
I wasn't totally.
What is it, Kathleen?
In preparing for us to discuss this item next time, it would be helpful if the staff could do a bit of thinking or exploration around what our various options might be, including to which institutions we might go to request a report like this.
Okay.
Whether that be the legislature, an academic institution, or others.
So you want a research paper?
Yeah, okay.
So next question, would we, let's take this way down to the point where we're thinking of instituting legislation on this, would it be us seeking a sponsor, or would it be DCA?
DCA doesn't seek sponsors for legislation.
Okay.
So
would we go through
you
the
can
leg
sponsor
unit?
you can sponsor your own legislation without any kind of approval. Sometimes, however, the boards will run it past the director just to see if there's any objections to anything, because, you know, they do answer the governor, and if the governor doesn't like a proposal, there's no point in moving it forward. So, that may be an option to run it past, but a lot of my clients don't. If they really feel strongly about something, they will seek an author and get in a bill and then work from there. So it just depends on, I guess, your risk analysis or your comfort with moving things forward. But yeah, I mean, the boards are semi-autonomous in this regard. They are, in that they can sponsor their own legislation. Of course, you want to follow any conflict of interest rules and guidelines if you can when you're proposing things. But like I said, I mean, there's no requirement that you run it past the department before you seek an author. So.
But that would be a smart thing.
Well, it depends on how controversial you think it might be. And I don't
think
know.
It's a 10 out of a 10.
Okay, well, I mean, that's your call, but like I said, you're not required to.
I mean, we're potentially proposing a legislative bill that costs $25 or $30 million. It's gonna land on the governor's desk if it
Okay,
gets through the
that might be,
legislature.
yes.
Just so I'm
Looking to
clear,
Catherine for legislative
who
loss.
pays that? Do you know who pays that, just so that
Yeah.
I'm clear, who pays?
And that's the key question. You're
Okay.
looking at me for legislative thoughts. I think Sonia just raised them. So, I think that that's probably not the starting place.
All right, is the professional association interested in any of this?
Interested but not at liberty to comment at this time.
Would you put it on your next agenda at a board meeting?
Interested but not at liberty to comment. I mean, yeah, we'll take it to our board and talk to them, but that's all I could say for right now.
Okay. We'd just like to know who our friends are on it.
Well, I think the comment about fiscal, you know, we all know, you guys especially know how the California budget looks. So we will discuss it, but that budget would play a big part in this.
Okay. Mary, do you have any thoughts? All right, so staff will come back with the appropriate information.
Yes, sir.
And the committee will reach out to the committee.
I do hope we can also be clear to thank everyone who joined us today, both those of you who are here and those who left the room as well, that we reach out to them. This was a really, really helpful conversation.
Okay, and just a reminder, committee probably can't reach out to committee because it might be a quorum.
It's a two-person committee.
Right, but 2 to 2, because you have a 2-person committee, right? Two
No,
legislative
to the
committees.
He's just talking about
legislative
himself.
Just the 2 of you.
We're not on a
No.
committee together.
No.
He's the chairman.
No, I understand that, but I thought you were saying committee will reach out to committee, and I thought there were a legislative committee has 2 people on the
No.
committee and 2
He'll reach
people
out
on
to the select committee.
Yeah.
Okay, because
And the
4 would be a
No, that would be a
majority.
legal meeting.
Yeah, we're not.
Right, okay.
It's the committee
checking.
from the legislature,
Committee from the legislature. Yeah.
Okay.
not our.
It's not ours.
Okay.
Thank you, everyone, for coming
Yes,
in for your
thank you,
input.
everyone. We
Very
appreciate it.
helpful.
You're welcome to stay. We have agenda item number 21, agenda items for the next meeting. Obviously, what we just discussed.
Two other items we discussed during the meeting were, as the possible legislative proposal for moving all the the exam requirements in the statute so that you don't have to vote on the exam, passing score, and dates and locations anymore. You know, that the technical language would be worked out, but that's the concept. The other one was the application fee analysis that we discussed during the budget item that you were interested in pursuing, you know, just whether the application fee study and desk audit analysis for the application fee.
And did we mention about something about the CME audit process or something?
That's right.
Yes.
That's correct. There was a third item, because we hadn't noticed that the whole CME process, and you also talked about outreach, I believe, to licensees on the fact that you are going to be doing audits, kind of just an FYI to people.
Right.
And I would like to have update on National Commission of Certification and recertification of physician assistants.
I think, is NCCPA planning on coming to the January meeting? Don't they have a?
Well, we're working on that.
Oh, okay, all right, sorry.
That's possible, but I haven't heard from her.
Okay. Well, maybe could we add that item to the
possible
agenda just in case, so
presentation
that.
by NCCPA president or staff.
Maybe
And
just
then-
national certifying body, you don't wanna be too specific.
Okay, I like that.
General. I'm learning.
And maybe even possible presentation by American Academy of Physician Assistants regarding recertification. And then do we need to do anything with any of our regulatory things that we talked about today?
Right, we'll probably bring back the 1399.515 retired status regulation text proposal with the fee analysis.
And what about,
The rest of them would probably just be an update on your current pending regulations.
the proposed amendments reporting on.
Right,
physician
so we're
assistants,
looking at the current
supervision.
agenda would be 1399.546, 1399.531, and 1399.514.
And then education, workforce, and development.
I will report back on my visit to healthcare select committee from the legislature.
And then also, we would like Wilbur to come and tell us how broke we are.
I hope not.
And actually, Xavier asked me a very good question today. And maybe it's not on the agenda, so I probably shouldn't ask it.
Well, if you want a future agenda item, you can put it out there.
Okay. It's just a point of information.
One.
Does anybody audit the Attorney General's billing? Or do they just send us a bill and we pay it?
Your staff are supposed to.
Yes. We do.
Your staff are supposed to. I used to review them for my clients too, sometimes when they ask me to look at them.
It comes in
So-
monthly, we check it against the cases that we have out there, they give us the hours, so you guys put that.
So we can put that on there though, if you'd like.
Okay.
to
Yeah, I'd just
discuss
like to know if,
How you review the Attorney General's billings.
Yeah, and how-
If you have anything that you can contest and how you do that.
That was a 2-minute phone call turning the.
And it
Yes.
Because they charge us for every
I'm just
15
kidding.
minutes.
Well,
We're,
like I said, we can put that on a future agenda item, because
Yeah.
we're starting to talk about it.
All right, yeah, no, that's good.
That's the point of this, is for for next agenda. Just, it would be information we've never ever discussed in the 21 years I've been here.
Yeah, okay.
How do you figure out that we owe you $340,000 for April?
Point of information, can we reopen an earlier agenda item?
I mean, put it back on it for further discussion, sure.
Sure, okay. When we're done with this one.
I think that's everything there is. Anybody else have anything else for the agenda? Okay, Catherine?
You wanna move to reopen an agenda item?
Yes.
Yes, thank you.
When?
The dates, future meeting dates,
Okay.
which I wasn't paying attention to, because I thought I was no longer on the board after this meeting. So now that I'm looking at it.
Second, I need a second.
What's that?
I need a second,
I'll
and then we
second.
need to, we're gonna need to vote on that motion to reopen discussion.
I'll second.
I second.
Okay. And then, any?
Okay, so further comment by the board? Public comment? Call the roll, please.
Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay,
Okay.
I am sorry that I was not fully paying attention to this one earlier. We went with option 2, right? That includes
Yes.
the date April 17th. Did we discuss that the 16th is Easter, so people would be traveling here on Easter?
It would be Sacramento.
Or
See,
traveling to
back me
Sacramento
again.
on Easter.
Oh, boy.
Sorry guys, I should have paid attention
No,
earlier.
we actually said it
No.
already.
That's exactly what we try to
Yes.
avoid, but it
Yeah.
never shows up on the
We were just
state
thinking about
calendar.
Mother's Day, I think.
Yeah. Nothing in May, all right, we're good. Yeah, so probably need to change that date, huh?
We might want to move it later, considering that the next meeting isn't until August.
Yeah, so it could be the next Monday, which would be.
24th. No, so April,
We need
yeah, it'd be the
April-
24th,
April 24th.
yeah.
Okay, it looks like
Looks
medical
like
board is
early on
27th.
available.
Okay, so it would, we would then, do I need a motion?
Yes.
Okay, so
Change the date to April.
I need somebody to make a motion that we would move our April meeting to Monday, April 24th.
For the love of Easter, I move that we move that meeting
I will
to
second.
April 24th.
I will second likewise for the love of Easter.
Okay. Further board discussion. Public comment. Would you please call the roll for the last time?
Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay, so it's now April 24th.
So the dates are January 23rd, April 24th, August 11th, and October 16th.
That is correct. All will be in Sacramento except August 11th. Anything else? Thank you, Bryce. Thank you, Marshall Ketchum, for a great opportunity.
Need a motion to adjourn.
I will entertain a motion to adjourn.
So moved.
Second. Further discussion? Public comment? One more roll call.
Okay,
Get back to the list.
Aye.
Just taking notes. Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Thank you very much for everyone traveling to Southern California. Safe travels back.